Luckily, you didn't miss anything. We're ready. And I'll put also, like I said, you have because it was the only things that got voted on were the minutes and the curriculum, and they were both like unanimous.
All right. I think we're good to get going. Welcome, everyone. I'll give people a little bit of time to find seats. So as most of you will know, but perhaps not all of you, on September 14 last year, so at the beginning of the academic year, we kicked off this academic year's celebrations of the 75th anniversary of the modern law school with a gala event, a more lighthearted gala event over at the Isabel Bader Theater, followed by a reception here. And we said, stay tuned to the end of the academic year. We'll have a more scholarly an orientation event on tap for you that takes a look at the 75 years of the modern law school. And that's where we are now. The time really goes by very quickly. Here we are at pretty much at the end of the academic year and at exactly this event. But before I say more about this, I wanted to take a moment and reflect on the land on which the University of Toronto operates. I came to the University of Toronto some 25 years ago, and to Canada some 10 years before that. And in this time, I have learned a lot about the history that has brought us here. And so I want to acknowledge that for thousands of years, this has been the land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. And today, this meeting place is still home to many Indigenous people from across Turtle Island, and at the Faculty of Law, we are grateful to have the opportunity to learn, to work, and to build community in a good way on this land. And so in this spirit, I'm thrilled to see all of you here, and I am certainly much looking forward to today's proceedings and also to tomorrow. This event for us is a wonderful opportunity to reflect on the contributions of some of the faculty greats over the years, and then to use their work as a jumping off point for thinking about how the issues that law grapples with, the law itself as well, and also how we think about the law and how we tackle it as academics, how that has changed, or perhaps not, over the decades. That's the idea behind the conference theme, Law in a Changing World, looking forward by looking back. This is the second in our Law in a Changing World conference series, so you may have picked up these lovely bags that have the overarching theme, Law in a Changing World, on it. The first conference a couple of years ago dealt with a specific issue, climate change, but given that this is our 75th anniversary year, we decided that this one was to take a slightly different cut at that issue. So the conference is organized. When you look at the program, there's of course many ways in which one could organize such an event, but we decided to keep it simple and be chronological in terms of when the tenure of the various scholars over the years, what their tenure at the faculty was. So we went with the first year of appointment at U of T Law, and one of the effects is that this is sort of a little bit of a historical commentary as well. Someone asked me, why are all the women on the second day? Well, when you look at when women actually started being faculty members, you'll see this quite vividly presented in the order of proceedings. So that's why, in case some of others among you were wondering about that. Obviously, there are also many, many other scholars whose work could have been represented in this book, but the way that Chris and I organized this was that we were basically inviting colleagues to pick areas and people that they wanted to write about, and so this is how this volume came together. And, or volume, I guess that leads to the second part of what I was going to say. We have this conference here as as an opportunity for us to have a conversation and a feel-good moment about all the things that the faculty has contributed to a whole range of debates over the years. But the lasting output of this is meant to be a special issue in the University of Toronto Law Journal, and then also an edited volume. So if you're already thinking ahead about things you might want as gifts for various occasions, maybe stocking stuffers, depending on how big the stockings are, think about this volume forthcoming. And then that was the plan. So as we planned this conference, as one does, quite a while back, this was the basic idea. And then as we were approaching the day of the conference, this was maybe sort of a month ago, and so we started saying, it seems a little odd to have a conference on law in a changing world where we do not also have an opportunity to think about what is actually happening all around us right now. So what is happening to law? What sorts of changes are we seeing in the world? What might their implications be for the law and us as lawyers and so on? And that is why we added a closing roundtable to the conference that will take place tomorrow over lunch. So you'll bring your lunch back into this room, and we'll have 3 people with the long view, and I have to say, this might give it away, I'm sort of one of them at this point, thinking about sort of over, again, maybe not 75 years, but a number of decades, how different is what we're dealing with here. So, with that said, I will not really take up much more airtime. I'm delighted now to introduce, really only literally by name, our panelists, because probably all of you will know who they are. And I'll start with Carrie Rittick, who is not Brian Langell, but who has very graciously agreed to step in because due to some unforeseen circumstances, Brian is not able to be here. So thank you very much, Carrie, for stepping in to offer some reflections on Bora Laskin's work. Then we have Mariana Mota Prado, and I will not try to mention her still relatively new title in the university because I'm bound to get it wrong, but we're proud to say that she continues to be a very actively engaged professor here at the law school, and she will speak to us about John Willis. And then I will, last not least, Chris Essert, our amazing Associate Dean JD program, and many other things, who will speak to Caesar Wright. And because Cecil Caesar Wright is sort of at the origin of a lot of this, if not all of it, we will start with Chris and some reflections on Caesar. And maybe I'll just say our speakers will speak for 10 to 15 minutes, and then we want to be quite interactive. And to the extent that, I guess this is not the case for this particular panel, but otherwise we will also want to invite any objects of discussion who are in the room to perhaps say a couple of words first. Chris.
Thanks, Jutta. Thanks everybody for coming. I wanted to just add one further thing about the discussion, which was, as Jutta said, like one of the upshots or the aims of this event is the volume that's going to come out of it, and we're hoping, in fact, we're sure that it's going to be a really serious academic collection that people will be referring to for a long time. At the same time, at least from my point of view, I think it would be really neat if during the course of the event itself, some of the discussion might be able to have like a little bit more of an informal character. I know that there are people in this room who will have had relationships with or know some of the people who aren't in this room, and I think that it'll be a neat opportunity to get some of those people's perspectives on some of the members of the faculty who are no longer with us. So in that spirit, as Jutta said, Cecil Wright was is the fountainhead of the institution, and so when Jutta and I were thinking about writing the chapter about Wright, that was our focus. So obviously Wright was a hugely productive member of the legal academy. He's described as the father of Canadian tort law. He was the editor of the Canadian Bar Review, of the Dominion Law Reports. There's a lot of ways in which Wright played a number of roles in the legal academy and the legal profession that when you kind of think back on them and you imagine what it's like to be somebody like me now, it's sort of like mind-boggling, like how much stuff he was able to do during his career. but rather than kind of concentrating on any of the substantive legal work that he did, we thought it would be much more interesting and appropriate in the context of the event to talk about Wright's sort of theory of the law school, right? So the idea of the faculty of law as the idea of what he calls a liberal professional education, and what it is that Wright, along with Bora Laskin and Stanley Edwards and John Willis, might have had in mind when they took the march up University Avenue, as it's sometimes called. So I won't go into a lot of detail about the history itself. I rather want to talk a little bit about what I think Wright might have been thinking in thinking that we needed to have an institution like this one. And so what I'm drawing on to do that is a couple of articles that Wright published. Although articles might actually be generous. I think both of them, each of which they were published in the Canadian Bar Review, one in the 20s and one in the 40s, they're actually just sort of recordings of speeches that he gave to the annual meeting of the Canadian Bar Association, I think both times actually in Vancouver. So in these two speeches, so one of them when he was still working at Osgoode Hall as a professor, and then one of them after this law school had been had got up and running, Wright was trying to kind of give a characterization of what he thought the law school ought to be doing. So initially that was why there needed to be a law school like this one, and then subsequently, what the kind of vision that he had for it was. So in thinking through this, the thing that was actually interesting to me, and that I'll sort of focus my remarks around, is this. You might have thought, it may in fact have been true of me, that I did think that the picture that Wright had in his mind was basically like things needed to be more academic rather than practical. And I think that's actually not the right picture of the matter. It's pretty interesting. So the way that I was able to see that was actually with the help of Jim Phillips, who I think will be here later this afternoon. And the way that Jim put it was, well, there actually already was an academic law school at the University of Toronto, right? Which is the law school that WPM Kennedy was running. But there's a sense in which that's true, and there's a sense in which it's not true. And the sense in which it's not true is that although there was a part of the university that was dedicated to the academic study of law, it was nothing like what we would now want to call a law school. And I think seeing what's going on there allows us to kind of locate Wright's notion. So what's going on, by what's going on there, I mean the fact that Wright was, on the one hand, not satisfied with what was happening down at Osgoode Hall, and on the other hand, I think not satisfied with what Kennedy was doing here. So what do I mean? Well, what was going on at Osgoode Hall was something that Wright, I think, thought relatively plausibly, as I understand the facts, was kind of too narrowly practically oriented. So it was just a matter of, as Wright sort of describes it in his writings, teaching people really kind of quite practical, hands-on, sort of following precedents produced by earlier lawyers, learning rules by rote, nothing like the kind of legal education that we understand ourselves to be delivering or had delivered to us these days. On the other hand, as I said, Kennedy's school was a school that took law seriously as a subject of academic study, but Kennedy didn't, I think, in any way purport to be offering a training for lawyers. And I think what Wright wanted to do, and what he describes as providing a liberal professional education, was do something that in a certain way charted a path between these two different models. So I think what Wright thought that the law school needed to be doing was teaching people how to be lawyers, but that Wright thought that teaching people how to be lawyers was not remotely just a matter of memorizing a bunch of rules, or as he describes it at one point, learning how to make sounds like a lawyer makes, but rather learning how to think about the world in a particular kind of way. So Wright, I think, had in mind very early on the idea that what a law school did was, as we would put it in 2025, teach people to think like a lawyer. And when Wright was articulating his vision for the law school, what he tried to do, I think pretty successfully, although as I'll say, it's not an easy task, is to try to explain what that expression means, what it means to think like a lawyer. So the way that Wright goes through that process of trying to articulate what it means to think like a lawyer, what it means to teach people to think like a lawyer, is actually by noticing that in his time, the work that lawyers were doing or were beginning to do was much different than the work that he understood lawyers to have been doing a generation in the past or before that, right? So there's lots of complexities around this, but the kind of simple way to say it is something like, well, lawyers 50 years before Wright's time were sort of doing like really narrow kind of private law stuff, right? So transactions, contracts, conveyancing, real estate law. And Wright saw that over the first half of the 20th century especially, there was this massive development of the administrative state, massive development of the role of legislation in the legal system, and that meant the scope of things that lawyers were engaging in became massively larger. And that posed the problem for Wright, which is to say, well, what is it that's going on across all of these different disciplines that is at the same time kind of substantively different in the matter of the, you know, the words that are being said, the forms that are being filled out, the forms that people are making arguments at, different in those ways, but at the same time, all the thing that lawyers do. So Wright wanted to try to articulate some sense of what it is that lawyers were doing that could be applicable to all these different contexts, right? So the way that Wright did that is he sort of took this big step back and he said, look, fundamentally the job of lawyers is the construction of a society. He says at the highest sense, we can describe the work of lawyers as the building of a civilization. And it's such an incredible idea that that's what we're doing. And I mean, that's the idea that I have. It's that there's some sense in which we can't have anything like a civilization as we understand it without law and lawyers. And so Wright says that if that's what we're doing, that has to be the guiding light in terms of the way that we're educating lawyers and the way that we're thinking about things. So he brings this big idea into the context of kind of legal education by noticing that, again, the contrast with the earlier form of education, as he saw it, it was very backwards looking. It was, this is how things have been done in the past. We're going to teach you how things have been done in the past. And Wright says something like, that's not the way that lawyers think. So he says, I'm going to read some quotes. He says, in a sense, finding the law is the whole concern of a lawyer and consequently of the law school. The difficulty is that there is often a tendency to regard the law as a set of detailed rules or concepts. But he says this isn't the right way to think about it. He calls this the slot machine conception of legal thinking. He says rather finding the law is characterized by this. It's not characterized by the search for a case on all fours. And here, just to jump forward to a panel later on, here these words to me are extremely resonant of something that Chief Justice Laskin says in Harrison and Carswell, which is like one of this famous decision that we teach in first year, where Laskin says, look, the job of understanding precedent is not the job of asking whether this case is about a brown horse in the way the previous case is a brown horse. So Wright says, look, we have to think about the ways in which we can take the learning of the past and apply it to the problems of the future. And so I think he wants us to see that there's a certain set of modes of thinking, a certain set of forms of thought that are distinctive of legal work, of the legal profession, and therefore of legal education. And the job of law school is to inculcate students into that way of thinking about the world. So I'm gonna read this. This is now me speaking, but I'm just gonna read this because I don't want to get this wrong. I wrote it relatively effectively. So the core of legal education for Wright might be said to consist in this: by reading and reflecting upon past judgments and modern legislation, one learns to discern from those things the principles and concepts appropriate to some sets of circumstances, and then, and this is for Wright the crucial move, to apply those concepts and principles to new circumstances and to develop new concepts and new principles to apply them in turn to their own circumstances. It is this process that allows students to begin to develop a feel for the distinctive patterns of reasoning and argumentation that make up so much of the law, and to understand the relationship between those patterns and ideas of judgment, relevance and irrelevance of particular facts, and so on. That's the job. That's what we're doing here. And I think what Wright wanted us to see is that that's what a law school is supposed to do. And so you can't do that on the one hand by just teaching people to memorize the way things were done 50 years ago, but also at the same time, as important as interdisciplinarity is, as important as various forms of other parts of the academy's projects are as they relate to the law, teaching people to be lawyers is not just a matter of teaching people to understand that there's such a thing as a law that can be studied. It's teaching people that there's a distinctive form of human social practice here, and that's what we're teaching people how to engage in. And I think by seeing that, I think Wright actually kind of gave us an agenda for the law school that we're still following. So just by way of closing, I'll say two things. I mean, in terms of the looking back by looking forward thing, there's lots of stuff that Wright says that's really kind of shockingly relevant to our contemporary circumstances. So there's a narrow one and there's a broad one. The narrow one is this comment I made earlier about how teaching people to think like a lawyer is not teaching them to make sounds like a lawyer. When I read those words, I thought, wow, it's weird that in 1948, Wright wrote an article about generative AI. Right? So that's what generative AI does. It makes sounds like a lawyer. And I think Wright says this comment in the context of if we're going to claim a monopoly on the provision of legal services, we need to be able to explain why it is that there's something that we're doing that nobody else can do. And that problem is, I think, more pressing than ever in the face of Gen AI. And I think the job of thinking about how the faculty of law or how the legal community in general is meant to respond to generative AI is that's the problem, is to be able to explain what thinking like a lawyer is, as opposed to merely kind of replicating the words of others. So that's a narrow one. There's obviously a lot to say about that. And then the second one is this bigger point that the job of law is to kind of to participate in the building of a civilization. And I think I won't say anything substantive about that except to say that's what the last panel is about, right? So we have new problems these days. Are they bigger problems than the problems that Wright had? I don't know. I mean, the two articles that the two speeches that I'm referring to, one was written before the Second World War and one was written after. And the greatest, the worst event, sort of human created event in the history of the world, didn't dim Wright's optimism in the power of law to participate in the building of a civilization. And so as bad as things are now, I think we have to maintain that optimism, maintain that picture that we have something special that we can offer here, and that's what we have to continue doing. So I'll stop there. Thanks.
Okay. Hi, everybody. So it's really a pleasure to be here talking about John Willis, but it's also a bit scary because this is not only a very important figure, but it's a scholar that a lot of people have written about. Many of those are here in this room. So what I'm going to try to do is give you a little bit of information about how important John Willis was for Canadian legal history, and then outline the arguments that I'm trying to articulate on my paper. So let me start by connecting with what Chris just said. If you go to the website of the law school and you click on the brief history of the law school, on that page you're going to find a photo of the three scholars that we're talking about here in this panel. And there is a little sentence saying, joined by colleagues Bora Laskin and John Willis, Wright immediately revamped U of T's law programs. So I think John Willis was, very much like Wright, a very important figure in this reconceptualizing of legal education in Canada. But the part of his contribution that I want to focus on is more on the administrative law side of things. And as Chris already mentioned, that was an emerging field that wasn't fully incorporated into legal education at the time. So John Willis is coming in as a quintessential figure to help us conceive how public law and the administrative state should be embedded into legal education. Because he was trying to do that, he was a very transformative but also controversial figure. He was trying to push the status quo away from their comfort zone and trying to push practitioners and scholars to think differently from the way they had been thinking until then. And the paper, there is a lot of writing by John Willis where this attempt to change the status quo is very eloquently and forcefully articulated. But I picked one piece that's called Three Approaches to Administrative Law: the Judicial, the Conceptual, and the Functional, which is a relatively earlier piece. It's a piece he wrote in 1935. In order to illustrate what he was fighting against, what he was trying to push for, And in my paper, I'm cheating a little bit in my interpretation of the piece by saying that I'm not trying to say that I'm proposing a brand new interpretation that nobody has ever seen or thought of. I'm articulating this as I'm bringing a pragmatist framework. The pragmatists were in the US in the 30s at the time that Willis was writing this, starting to build their body of writing. I have no evidence whether Willis was aware of this scholarship, and I'm not by any stretch of the imagination claiming that Willis was actually influenced by them. I'm doing a more hypothetical exercise of if we were to import some of these conceptions and principles, especially the framework that pragmatists use in order to read what Willis is trying to do, what do we come up with? And in doing that exercise, I'm hoping to convince you that some of the criticisms against him sort of fade away if we interpret him as a pragmatist, but I'm not claiming he was one. So that's why I said I'm cheating a little bit. I'm sort of not claiming anything very strongly here, but in a way, I think I'm trying to give the best interpretation possible of his work. So what does he do in this piece? Basically, he criticizes what he calls the judicial view by saying that courts embrace formalism. He's especially bothered by certain categories which drive a lot of the administrative law at the time, which is the distinction between judicial, quasi-judicial, and administrative decisions. Some of these at the time were not reviewable by courts, and some of them were. And that drove a lot of the discussion about what's the role of courts vis-a-vis the administrative state. And Willis was saying, let's abandon formalism. It doesn't make any sense for these formal categories to be driving our analysis of what's the role that courts should be performing vis-a-vis the administrative state. And a lot of people read this criticism as driving then an argument about let's take the courts out of the picture. They are formalists, they don't understand what the administrative state is doing, they don't have the expertise, and therefore they shouldn't be part of this conversation. And indeed, in this piece, after criticizing what he calls the judicial approach, Willis does present what he calls the functionalist approach, which is an approach that basically proposes that we need to analyze the functions that these bodies are performing, and this functionalist analysis should be driving our decisions. So I'm just going to read for you to get it right, as Chris said. So the judicial approach aims at preserving the internal coherence of the common law's protection of individual rights, creating a response that's frankly hostile to the administrative state. And instead, he is trying to push us to an approach which he calls the functional one, that articulates the need to consider what works by looking at the functions performed by governmental bodies and which are the best fitted to perform them, both in the exercise of government functions and in their review of these functions. And if there isn't such a body, we need to create one. So in this piece, after presenting the judicial approach, where he says the courts are too formalists, they cannot be doing this work of judicial review of the administrative state, he proposes a brand new arrangement, which is this creation of this independent body that is supposed to have people trained in what the administration is doing, but also people trained in law in order to do judicial review of administrative action. A lot of people read this as resistance to the judiciary. And by bringing the pragmatic framework, I'm trying to question that by saying pragmatists at the time were questioning this idea that there is truth And basically, they wanted to challenge that by saying we develop beliefs by looking at our experience, and those beliefs can be revised. So a little bit of my reaction to everybody who says, oh, Willis had too much faith in the expertise of government and too little faith in the courts, and that was unfounded. My response is that was what he inferred from what the courts were doing at the time. And my question is, what Willis would have said about what the courts are doing today vis-a-vis the administrative state? And so I'm trying to suggest that people interpreted him as an essentialist, as somebody who saw the courts as absolutely incapable of changing the way of thinking, and as a body that should never be involved in the judicial review process. And I'm sort of asking, maybe it wasn't that essentialist. Maybe he was just looking at what was happening at the time, resisting the courts at the time, but if he looked at what the courts are doing today, he would be fine. So the second point that Willis raises is the conceptual approach, and he criticizes that by saying this approach relies on, and I'm going to read here, resorts to abstract categories like the rule of law that presume that only courts can review administrative action and assume in this process the likeness in unlike things, as illustrated by the distinction between judicial and quasi-judicial functions. So here he takes a very big bite against the rule of law, and of course that drives a great deal of criticism against him. One of our colleagues, David Eisenhower, has articulated that, I think, in the best form possible. But again, I just want to take a step back and ask whether what he was trying to do here, right? Because I think there is a lot of people that read him here as a consequentialist, as somebody who says, let's abandon abstract principles and let's just look at the consequences. And I'm not disputing that interpretation. He was immersed in legal realism when he studied at Harvard before being hired at Dalhousie and then moving here to U of T, right? So entirely plausible interpretation of his work. But I think if we look at this from pragmatist lenses, what he's trying to say is that the legal system is not a coherent body of rules. There are rules that protect rights, and there are rules that promote the welfare, social welfare. And he's really concerned about trying to reconcile these two functions. And he's very frustrated with the fact that the common law and the discourse around the rule of law at the time was entirely centered around rights protection and had no room for this additional function, which is the welfare function, the social welfare function, which was promoted by this brand new public administration. So once you bring in that assumption, meaning the assumption that Willis might be a pragmatist who doesn't see the legal system as a coherent system, I think this criticism that he was a consequentialist who didn't care about the rule of law disappears, because it's the driver here is an entirely different driver. It's an attempt to recognize that the law may be doing different things at different moments, and he's really concerned about this clash, right? The clash that at the time public administration is being reviewed by courts that don't speak the same language. That's the clash he's primarily concerned with. So let me finish by talking about his proposal of a new tribunal. And I think he, as I said, ends the paper by saying we don't have a body that can suitably do judicial review right now, and therefore we should create a brand new one. And a lot of people read this suggestion as creating an administrative tribunal. And my reaction is, I'm not necessarily sure that's what he was proposing. He talks about this tribunal about being independent, about having legal experts, but people trained beyond the common law, about a very new idea that I think resonates with, you know, Bruce Ackerman's piece on Adieu Montesquieu, with Mark Tushnet book about the institutions in defense of democracy, which is a fourth branch of government. So I think Willis was really pushing us to abandon the separation of powers principle as it was traditionally conceived and think brand new things that didn't necessarily fit with these formalistic categories. And if we think about this idea of a new tribunal in that way, he was really, I think, ahead of his time. He was really proposing things that we're discussing today, right? So let me just close by saying I think Willis would be really pleased with the state of our admin law today. The distinction between judicial, quasi-judicial, and administrative has long been abandoned in Canada. On the UTLJ issue, the first issue for this year, there is an article by Joanne Murray where she articulates that judicial review is actually not adjudication per se, but it's a sort of a dialogue between courts and the administrative state, which I think also suggests that courts are doing what Willis would like them to do, and the essentialist view doesn't need to be assumed here. And finally, we have abandoned what he calls questions of jurisdiction in Vavilov, so which he criticizes heavily in this piece. So this is, I think if he was sitting here today, he would be very happy with where the law school is and where administrative law is, and I'm looking forward to your reactions to my renewed interpretation of his piece. Thank you.
So thank you, Jutta and Chris, for the invitation to participate. I only wish Brian were sitting here with us. He would surely have an enormous amount to say that we'd want to hear. So let me start with the most controversial proposition, which is that there are many people much better positioned than I am who've written about Bora Laskin at length and in some depth, because they were his friends and colleagues here at the Faculty of Law or on the bench, because they served as his clerks, and simply because he is one of the most inexhaustibly compelling figures of Canadian law. But I thought, because I think it's a good moment to reflect on the significance of cross-border connections, I would say something about Bora Laskin's pivotal role in the transmission of legal ideas, practices, and influences across the US-Canada border. I want to suggest that Bora Laskin became, in the end, the most significant conduit for the entry of developments in US legal thought, education, and practice into the world of Canadian law, developments that occurred really over a long span of the 20th century. These were developments that he then took up, himself elaborated and transformed, and of course ultimately deployed in distinctive ways in quite different historical and constitutional context. So although Bora Laskin spent a relatively short period of time directly immersed in the US legal world, as a graduate student at Harvard Law School in 1936 and 37, he was uniquely positioned to play this role as conduit because of the powerful and transformative influence he exercised in virtually every position he occupied. Professor, labor arbitrator, appellate judge, and of course, finally, the Chief Justice of Canada. Let me briefly illustrate this proposition by discussing three areas: legal education, labor law and cross-border linkages in the labor law professoriate in particular, and finally adjudication. Bora Laskin's role in provoking and then entrenching successfully paradigm shifts in legal consciousness and adjudicative practice. And I'll mention that I think in all three areas, Harvard Law School stands out as a touchstone or waypoint. It's hard to overstate how influential his time at Harvard Law School was, both to his conception of legal education and to the trajectory of his legal thought in areas of labor law and administrative law in particular, something that he then, of course, brought back to generations of students at the University of Toronto. And here, too, I think the independent significance and value of these inter-university institutional connections are worth highlighting and, I will say, protecting at a moment of disruption on the geopolitical front. Okay, so I'm going to be really brief when it comes to legal education because Chris has done already a wonderful job of talking about what started out at the inception of this law school. As Phil Gerard has really described as well, the Harvard model of legal education dominated the imaginaries of Caesar Wright and Bora Laskin. In retrospect, what is really striking to me is how remarkably late to the party Ontario was when it comes to the project to normalize academic legal education as a path to the profession. This model of legal education had already been introduced at Harvard itself in the 1870s, and universities in both Eastern and Western Canada had already followed. And I can't help but think that after his time at Harvard, Bora Laskin must have felt simply incredulous at having to defend the need for serious academic training and intellectual inquiry into the law. Okay, so on to labor law. So more than 40 years ago now, in a symposium issue of the UTLJ honoring Bora Laskin, David Beatty and Brian Langell wrote a masterful synoptic account of Bora Laskin's influence on the field of labor law, one that I think is really as complete for general purposes as we might hope to find. As they describe, Bora Laskin literally made the field of labor law in Canada. He was the professor of labor law here. He was a massively influential labor arbitrator, authoring groundbreaking decisions that we still read, teach, and think about today. As a judge, he wrote decisions in administrative law that were core to preserving what he took to be the heart of the labor law enterprise, which was protecting the jurisdiction over labor disputes that legislatures on both sides of the border had consigned to arbitrators and labor boards, from the perennial temptation on the part of courts to claw it back. Okay, so Bora Laskin's views on these subjects were clearly forged during his time at Harvard Law School, and here I think it's worth noting that he attended Harvard only 1 year after the passing of the National Labor Relations Act, and at a moment when absolutely titanic battles between courts, legislatures, the executive and administrative agencies were just turning the corner. Many of these struggles were directly centered on labor conflicts. And as Mariana has outlined with respect to John Willis, at the heart of Bora Laskin's vision was a rejection of purely conceptualist approaches to contract adjudication that were informed by the will theory, in favor of what he took to be a more open assessment of the competing social and economic interests at stake. This was not an argument that still had to be made in U.S. courts. Conceptualism had been pretty decisively displaced in American jurisprudence at this point, but due to the ongoing weight of English precedent, or perhaps simply precedent in general, not yet in Canada. Okay, let me turn the focus slightly and tell a story about Bora Laskin's place in the Canadian labor law professoriate. So a number of years ago, for a festschrift for Paul Weiler, then the professor of labor law at Harvard Law School, in a paper defending some of the normative objectives behind labor law that have been under assault for the last generation, which is something that labor scholars do all the time right now, I placed Paul Weiler in what is an almost unbroken line connecting labor law in Canada and at U of T in particular to Harvard Law School through its professors and students who then went on to become professors themselves. So let me just elaborate a little bit on this story, this connection, because it's a genealogy that really begins with Bora Laskin and his time under his mentor, the great administrative lawyer and later Supreme Court Justice Felix Frankfurter. Frankfurter's labor injunction, which he co-authored with Nathan Green, is a groundbreaking analysis of the use of the labor injunction. Both of them placed the use or abuse of the injunction at the heart of the labor conflicts that were then roiling the legal and constitutional order of the United States. Okay, so from Bora Laskin, the line continues with Harry Arthurs, who was a student of Bora Laskin's during the founding period of this law school. Harry is himself, of course, an undisputed titan of labor law in Canada, but also the person most directly responsible for forging connections between Canadian and US labor lawyers. Here I think I only need to quote the title of Harry's article to indicate the force of the Frankfurter-Laskin legacy already by the 1950s. Here's the title. Woe unto you, judges, or how reading Frankfurter and Green, which of course he did under Laskin's influence, ruined me as a labor lawyer and made me as an academic. The story then moves to Paul Weiler, who was a student of Harry's. Paul Weiler, after a legendary period as the first chair of the BC Labour Relations Board, first visited Harvard Law School as the Mackenzie King Professor of Canadian Studies, but after that himself became the Professor of Labor Law at Harvard, where he spent the rest of his career. And among the many things that he did there was engage in very serious comparative analysis of the US and Canadian approaches to the implementation of the US model of labor law, which Canada had adopted. Concluding that Canadian labor law, under the influence of Bora Laskin and Arthurs, had evolved in ways that were decidedly superior than the US one, certainly at protecting the legitimate interests of workers, quelling unfair labor practices, which remain rampant in the United States, and at generating stable labor relations. And just to continue the story more or less up to the present time, some of us then became students of Paul Weiler at Harvard Law School, only to return to U of T to teach labor law. But this is in fact only part of the story. The influence of Frankfurter and Laskin has really ramified across the country because of a collectively produced case book, which virtually all labor law professors teach from in Canada. And I think it's safe to say that this casebook still bears the imprint of Laskin and his intellectual progeny at every turn. Perhaps the best way to illustrate this is to point out that unlike the practice in the United States, where the different legal regimes governing work are typically given their own separate courses, we have, for as long as I can recall, taught a single course on the law of work that combines the contract of employment, collective bargaining law, and anti-discrimination law. I think this reflects the influence of Bora Laskin, someone whose pedagogy and legal vision ranged across both private and public law, and who fully resisted the idea that complex legal questions could be successfully resolved in doctrinal silos. Maybe just one or two word, if you'll let me prevail here. There's a very long debate about whether and the extent to which Bora Laskin can be described as a legal realist in the American tradition. And there are good reasons to ask the question. Rather than take a position on that contested question, I think I'd rather highlight instead the very broad transformation of adjudicative practice in the US over the 20th century, which involved the introduction of social science evidence, open consideration of legislative purpose and the consequences of legal decisions, balancing considerations. These are all, of course, standard adjudicative techniques on both sides of the border. And they're techniques which, it seems to me, Bora Laskin played an indisputably central role in both introducing and normalizing. So let me stop there by just observing that Bora Laskin never lost his critical edge. I think it's pretty easy to talk about what he remained opposed to. And I find him a remarkably energizing and helpful person to think with going forward as well. He would surely be interested in the incredible contestation among legal and political institutions that's underway at the present.
Well, thank you, Carrie, and thanks again to all three of you for getting us off to a rich start. And I could see nodding and smiling. I didn't see shaking heads, but I assume that this has stirred up some debate. So I would encourage all of you in the audience to engage with our panelists, but also, as Chris suggested, if you have something to share that would add to the picture that's being painted, that would be very welcome. We do also have a more high-tech solution for asking questions through Slido. I don't know whether all of you are signed up to it in the audience, but this is particularly relevant for those of you who are joining us online. So if you would like to participate, you can submit the question in writing. I'm looking at the computer right now and I can bring the question to the audience. So who wants to break the ice? As you know from your own classrooms, to the extent that you are fellow law teachers, it's always important to have somebody to ask the first question. So who's going to do the honors? Yes, Angela, thank you. Angela Fernandez. Do we actually have a microphone that we can...
So much. I don't know, is it on? It's on, okay, great. Chris, this is for you, and it's a lot less a question than a comment, which is just to say, in the Fiercest Debate book, I remember there's a detail in there about Wright saying he was going to ditch the jurisprudence class here, and he was like, oh, Roscoe Pound is going to be so mad at me, so like, shh, nobody tell him, you know? And that could be helpful, I'm thinking, to your point about it's not really a theoretical practical divide, because I totally agree with you that he was not necessarily on the theoretical side in the sense that he was quite impatient, actually, with like that kind of very abstract stuff, and that could be a good place for you to just, you know, ground that in.
Thanks, Angela. Yeah, no, that's a great point. I had the pleasure of reading the book in preparation for this, and like I think the thing that I should have said a little bit more clearly is that this idea of the liberal professional education is the idea is that the education is supposed to be liberal in the sense that it takes advantage of all of the learning from the different parts of the university, right? But it's also supposed to be professional in the sense that primarily it's directed at a certain kind of professional set of outcomes, right? Namely, learning how to be a lawyer. And I think we could debate with Wright, I think, probably about how important different kinds of legal theorizing are for that project. I think not everyone in this room is going to have the same picture of that, right? But I think one thing I thought about writing when I wrote this chapter, or the draft chapter that Jutta and I are working on together, was it's an interesting feature of this law school that you notice when you go down to the United States, how a lot of the people who are kind of well-known legal theorists in the United States are kind of in more that not to attribute that to Pound himself, but that model that Wright's rejecting, right? So people who kind of like do economics or do philosophy or something like that, and actually don't really care about the law. Whereas that's, you know, systematically not the picture that you have at the University of Toronto, right? That it's we're fundamentally interested in the subject matter that is the subject matter of the law school. So yeah, no, that's great. Thanks.
I wonder, Marty, whether I could put you on the spot, not to necessarily comment on any of the papers, but Chris referred to this transition from, there was a law faculty, there was a law school, so we obviously were celebrating the anniversary of the 75th anniversary of the modern law school. So what was that? Would you share Chris's view of the transition from something that was purely academic to something that was quite different?
Well, I hesitate to comment. I was in the second year of Wright's course, and I'm not sure that we could see much difference between Kennedy's approach and Wright's approach. The real difference was in the structure of legal education. They had eliminated the working at the same time in the law firm, but I think that there wasn't that much of a difference between Wright, Willis, and Laskin. I had them all as students, and they were much the same in their approach to how to analyze cases, going from one case to the other. The case books started in that period. Wright had his torts case book. Laskin had his. I don't know if Willis had a case book, but I don't think I can contribute as much as you think I should be able to the difference. I mean, I wrote the book on Kennedy, and he was a very scholarly person in the same tradition as Wright and Laskin. But I leave it to others to comment.
Oh, thank you. That was just wonderful, by the way. Really totally enjoyed it. And just wanted to link up what Carrie was saying about the influence of the U.S. Legal Academy, sort of back to your point, Chris, and maybe what Jutta and Chris are writing. When you were talking about Wright steering a middle way, you didn't particularly talk about the U.S. model, but it seems like it must have been very present in his mind. So I just wondered if you guys had some reflections on that, because I think that's sort of one of the themes going through the whole panel. Thank you.
Yeah, so that's great, Mayo. So I think you're quite right to say that, you know, in the same way as Laskin, right? Wright had gone to graduate school at Harvard, and it was clearly, like, you know, monumentally influential in terms of the way that he thought about things. But I think the thing that's sort of notable about the works that I was reading is that you know, in another kind of like looking forward, looking back sort of moment, Wright realized relatively effectively that the right way to pitch the need for a new law school was not, oh, well, we should do what they're doing in the U.S., right? So instead of saying that, instead of saying we should be doing it because that's what's going on at Harvard, he was, you know, he articulated in a certain sort of way what he took to be the kind of like fundamental reasons why legal education of this sort would be the right way to go. I mean, in the speech, in the second speech, the one in the 40s, he says, he sort of divides up his picture of what legal thinking is into three categories, and one of the categories is something like the possibility for critical reflection upon the law or something like that. And then he says, well, Dean Griswold, the dean of Harvard Law School at the time, Dean Griswold's here and he's going to give a speech on that topic tonight. So I won't say anything about that. I'll just sort of endorse what he says. So it's very clear, right, that he's influenced so much by what's going on, especially at Harvard. But at the same time, he wants to kind of give an original case in a certain sense for it.
Before we go to...
You have to, hold on.
Can
Mariana,
I just,
yeah.
can I just add one point? So Mayo, I think just in relation to that question, right? I'm trying to write about John Willis in the shadow of a lot of interpretation of his writing that builds on the idea that he went to Harvard and was influenced by the legal realists, right? So there is, I think, this entire assumption about all his body of scholarship that is an assumption he was a legal realist, and more than that, a consequentialist, right? So he wasn't with the CLS branch. But I think that's what I'm trying to suggest, not too forcefully. I don't want to say everybody who read him before is wrong, because I wouldn't dare to do that. But I think there is more subtlety there, and I think this tension of we want to abandon formalism, we want to embrace a more accurate approach of experience and reality, but it sounds like they were, at least Willis, there is a space to see he was trying to do something a little bit more complicated than just consequentialism, and I think that's what I'm trying to do in my piece.
Yeah, maybe just a brief word to say that the story doesn't end, of course, with legal realism. All kinds of things happen in the post-war era in the United States. For example, Bora Laskin's very acute attention to the question, who should decide this question, courts or legislatures, for example, is a central preoccupation of the legal process school in the post-war era. He's got a clear focus on policy, principle, and purpose. And in those moments, he sounds almost Fullerian. And then, of course, he was a major exponent of human rights, an enterprise that was intimately connected to the post-war constitutional rights revolution in the United States, even though he didn't live to see it play out in Canada in the form of the Charter. So I think you can see not only legal realism, but and what happened in the first part of the century, but amazingly important further developments in the post-war era as also being part of the story. Yeah.
Wonderful. So we're going to go to Ernie Weinrib in just a second, but I neglected to say, I think all of you, the temptation here is to assume that everybody knows who everybody is. May not necessarily be the case for every single person in the room, and also perhaps not obvious or visible for people who are following us online. So I just wanted to add that the very first question was pitched to Marty Friedland, who is, among many, many other things, a former dean of the law school. Then came in Mayo Moran, who is also a former dean of the law school, and now we're going to a pillar of the law school, Professor Ernie Weinrib. And once we've heard from Ernie and our panel, I do actually have a question in the high-tech version of the question and answer, so I'll bring that in. Please, Ernie.
Thanks very much, and thanks for these presentations, which I found very interesting. And I want to go back to Chris's treatment of Dean Wright, and this follows from what Marty is saying. Now, when I arrived at the law school, it was a few years after Dean Wright had passed away, when I was a student at the law school. But I'd heard a lot about him, of course, and it's fair to say that his spirit seemed to animate so much of the faculty's sense of identity, as I felt even as a student. And so I didn't know him personally, but on the other hand, I actually knew him intimately, because I took it upon myself when I was in second year in my spare time to read everything that he wrote. And that meant going through all the case notes.
A law student does that even today.
That meant going through all the case notes in the Canadian Bar Review on all the subjects he wrote about, which was phenomenal. And then years later, when I was on the editorial board of UTLJ, the question arose as to publishing his dissertation. And Dick Risk, who was then the editor, said, well, why don't you have a look at it and tell me what you think? So I read that in with some attention too. And what amazed me about him, he was clearly an amazing person with a great drive and a steel trap mind. That's the way he was described to me. You have to read Wright. He has a steel trap mind. But what amazed me about him was a kind of question I had as to why he actually wanted the law school to be in the university. Because there seemed to be very little evidence in his writing that the university, that is, the university, the wholeness of learning, was present to him or important to him. And I think part of that is maybe signaled by the comment about jurisprudence. And again, I have to say, when I was a student and when my first year as a teacher here, there were no courses in jurisprudence. And I was so imbued with the spirit of the law school that I thought that was fine. Who needed it? Anyway, but what I was amazed at is that there seemed to be a tension that he wanted, on the one hand, to be in the university, but there's no evidence that he actually used any of the universities, at least that I could see in reading his work, that he used any of the university's intellectual resources. And so he was, in a sense, in the university. That was an amazing step. And his drive in accomplishing that was amazing. And the range of things he wrote about was amazing. And not only tort law, which was also amazing, but his trusts, contracts, he wrote about everything. But he was in the university, but in a sense he was not of the university. The university, as a center of learning about various things, didn't seem to engage him very much. And I might say, and I think that was also evident in the legal education that I received as a law student, which I thought was an excellent education. I'm not criticizing it on that score at all. It was an excellent education. But I think that then leads us to, well, how did we get to where we are, which is so different? And I think the answer is actually, to a large extent, Marty. I think Marty was the first dean who then made it his business to show us the relevance of other disciplines to the study of law. And I remember, Marty, you had that series that was fascinating on courts and trials, where you had a philosopher come in. I remember it was Reg Allen, and you had Tony Dube as the psychologist come in, and many other figures from the university. And I think that actually, so I think in a sense, Wright had all the enthusiasm and virtue of a pioneer, but he didn't actually see the end of his vision, what his vision entailed. And I think for the next step in that realization, we actually have to acknowledge the contribution of Marty Friedland.
So maybe before I put it to the panel to react to this gauntlet thrown, I will bring in the Slido question, which sort of follows on this a little bit, and that is, what do you think Wright would think about the law school today? So you can approach it from any end of this. So Chris, do you want to start?
Okay, no, this is a lot now. Yeah, I mean, I think, Ernie, that's such an interesting comment, right? And I think the idea of the pioneer is like a really fruitful kind of metaphor in terms of the picture that I have, right? Because I think that in some sense the idea is going to be that Wright saw the potential for, the possibility for a certain kind of development of legal education, which he himself wasn't necessarily apt to participate in, right? And I think that's got to be the the way to sort of square that circle, to say that if it was, if it wasn't for that move, then Marty and everything that follows isn't possible in the sort of the same way. So I mean, what would Wright have thought? Like I think many of us still today, I hope many of us still today think that what we're doing is delivering a liberal professional education, in the sense that, and that this sort of does build on Ernie's question. That was the point I was trying to make before. I think there's so much, so many different ways in which members of this faculty approach the law, and different kinds of parts of the broader learning of the university that are brought into the different courses across the curriculum. But I think that there remains this kind of unified vision of the idea that what we're delivering is legal education, that what we're doing is actually teaching people how to think about the law in a certain way, and I think to think about the world in a certain way, in the legal way. And I think that one thing that, again, Wright's the suggestion that Wright makes, that the problems of the law are becoming bigger, that the problems of the world that the law is aimed to address are becoming more complicated, is the suggestion that in a lot of contexts, it turns out that you do need knowledge from other parts of the university in order to be able to understand the problems of competition law or health law or other areas. But at the same time, I think we do retain not to speak for everybody, but we do retain this idea that there's always going to be a sort of a core set of ideas that you can't actually outsource to other parts of the university. That there's a set of legal problems that are fundamentally legal problems, and you can always learn from what doctors think or what sociologists think. But there's also something that we're doing here, and I think we are still doing that here. And I think that's the professional part of the liberal professional education, and I think and I hope that that's something that's going to be at the core of the law school, for a long time.
I think I have two quick reactions. I mean, my first reaction is to think about grad programs, because I think one of the moves of being part of a university is not only to dialogue with other departments, right, but to have a training ground for scholars, as opposed to bringing professionals to be in the classroom. And I should know that as the former associating for the grad program, but I don't when we started having graduate students. So I think that would be a question. And along those lines, I just want to tip the hat to David Sandomersky, who is sitting right there, who is a former doctoral student here and wrote this very interesting doctoral dissertation where he interviewed every single contract law professor in Canada. And the finding was that in the discourse, they're all trying to rise above practice, but in the classroom, they don't seem to be doing anything much different from teaching the cases and the doctrinal analysis. And that came out in the form of a book. And I think David raises interesting questions about to what extent we have incorporated some of these principles in our scholarship, but to what extent this has actually turned into actual practice in the classroom, right? And I think there might be more of an aspirational spirit there than an actual transformational reality in front of us. So sorry to bring the celebratory tone down, and this is going to be disputed right here, okay? But I think it's an interesting question for us to think moving forward, right? Like, is it something that is David's work something that we should think about more deeply?
So I'm going to, of course, have to ask David in a moment to say what he thinks, whether Wright resonates in what you've found nonetheless, but I think Chris has a rebuttal, and then Carrie wanted in. So
well, yeah, so I'll just say, so this is sort of to foreshadow the third panel, right? But when I was in my first year of law school, I had Ernie Weinrib teaching me torts and Michael Jabilko teaching me contracts. And I think the thing that was that was an amazing experience in innumerable ways. But I think the thing about that stood out to me was I wouldn't swear an affidavit to this, but I would be surprised to learn that Ernie had uttered the words corrective justice or Kant or Aristotle a single time in that course, right? And then on the other hand, Michael was working through like a series of like quite complicated arguments about the economic implications of a certain set of problems in contract law, because it was right around the time that the limits of freedom of contract to come out, and the class discussion involved discussions of the same exact cases that are in the book, and you didn't need to know anything about economics to know that Michael was trying to tell you a way to think about contract law, and Ernie was trying to tell me a way to think about tort law, and it was, there are different ways of doing the project that are obviously in each case deeply informed by an understanding of other parts of human knowledge, but that it's a legal project in both cases. And I think the line that you hear, that, since we're both graduates of Yale Law School, what do you do? If you want to hire a lawyer, don't hire somebody from Yale Law School, because what they don't teach them there is the law. Nobody would ever say that about this law school.
Just a brief footnote. We seem to have to remind ourselves all the time that the original pioneers don't come with fully elaborated projects and ideas. It's the beginning. It's the opening salvo. And clearly many, many people, of whom Bora Laskin was one, played massive roles in elaborating the project. I can't speak to what Bora Laskin did in the classroom for obvious reasons, but I strongly suspect that Chris's description of the project as both performing how to think about a problem would have been his style. There's no question, in virtue of his engagement in labor arbitration, that he would have been thinking constantly about outside context. But also, he was well known as an incredibly active and valued university citizen. And so on some level, I'm sure that entered into the calculus in the classroom.
Okay, thank you. I'm David Sandomirsky. I teach law at Western University. Thanks, Mariana, for mentioning my book. I think what's emerging here is a really interesting trajectory that I think dovetails quite nicely into the way Chris has articulated where we are today. So if we have this image of Caesar Wright, not of the university, but still concerned to be in the university, and then we sort of progress to the Marty Friedland years and the Trebilco and the Weinrib years of interdisciplinarity. And then we find ourselves today at sort of a place, I think you articulated it well, Chris, where there's an integration of both of these views. So when I was doing some archival research, I was looking through the Wright papers, and I found very close to my heart this survey that had been sent from a very earnest PhD student at Dalhousie about legal education. And it was in Wright's papers. He clearly hadn't sent it back, but he had started to complete this survey. And one of the questions was, what do you think is the purpose of the law school or the academic law school? And he wrote, "To train lawyers, !" underline. And then he didn't complete the rest of the survey. I read this sort of frustration, like obviously that's what we're doing, to train lawyers. I think that's sort of consistent with Ernie's picture of Wright. And then years later, I was talking to Dick Risk, and he told this story where he said, if you woke me up in the middle of the night in the 60s when I first started teaching and asked me, what do you do? He said, I would have woken up and said, I'm a lawyer. And he said 10 years later, if you would have woken me up in the middle of the night and said, what do you do? He would have said, I'm a teacher. And so I think all of these things are kind of reflecting this trajectory that's happening within the university or at like U of T. And I think, Chris, you've articulated it quite well. I think what's more Harvard-like than Yale-like about this law school is that you're actually, one more anecdote that's stuck in my mind. Stephen Wadhams told me that James Milner told him that we teach an academic style of law not in order to train better lawyers, but incidentally it has that effect. And I think this is sort of what seems to be coming together, that there is a preoccupation with preparing people for the profession, but doing it in this distinctively academic and increasingly interdisciplinary way is just sort of like coming out, and Willis would have been like a really early, and Laskin, I think, manifestation of that.
No, I have nothing to add. That was great. That was great. Thanks, David. Yeah.
All right, great. So let me go over here, and if you also would just briefly introduce yourself so that everybody knows where you're coming from, so to speak.
I'm coming from a totally different direction. I'm Brian Westlake. I'm the class of 65 and had the privilege of all of the people that have been mentioned, including Dick Riss, first year as a teacher, but all of the three great men. For what it's worth, Willis was my god of the three of them. He was a fantastic teacher. The reason I'm taking the microphone is I deliberately overdressed today because the ghost of Caesar still haunts me. When the first day of law school, Wright said to the class, "A question that is frequently asked is whether you have to wear a jacket and tie to come to law school. The answer to that question is no. If you don't want to come to law school, you don't have to wear a jacket and tie." Any other questions? He was a fairly formidable figure. Intimidating, I think, would be fair to say. A little irascible, but a wonderful teacher. They were all wonderful teachers, and I had the privilege to be in there with them, and a very human experience. I say the jacket and tie thing for the benefit of the students of today who dress slightly differently. Everybody in our class wore a jacket and tie, and we had the first three women in the modern law school in our class. One of them even wore a hat. Maureen Sabia wore a hat to class, so it was a little more formal at the time. Artie Weinrib, Ernie's brother, was a real rebel. He used to loosen his tie a bit and come to class. It was pretty intimidating at the time. Thank you.
Well, there you go. So we're unearthing actual history of the law school here, and I wonder whether this will have any impact on the students here and what they're wearing to class tomorrow, but probably not. All right, we have time for one more question before coffee break, or one more comment or observation or anecdote. Any takers? Michael, wonderful. So Michael Tribilko, another one, well, already been made reference to.
I would just like to endorse Ernie's comment about the centrality of Marty's role in transforming the conception of legal education. It was under Marty, who was my first dean here, where we introduced various interdisciplinary programs, legal theory, law and economics, health law and policy, I can't remember what else. And I think that made us much more part of the university as opposed to in the university, and certainly speaking of the law and economics program in the early days, we had all kinds of cross appointments from the economics department and the business school, co-teaching courses with us. So the idea that we were a kind of an island and to ourselves, I think, started to be seriously challenged under Marty. Just on David's point, given all that, why do people like me teach contracts the same way as everybody else, out of the same case books? I actually feel guilty about this. On reflection. I was having a conversation recently with Connie Backhouse, who teaches at the University of Ottawa. She has a similar critique, I think, to David. Despite all our protestations, we tend to be teaching the same way. So I said to her, suppose I was teaching first-year contracts, as I did for many years, maybe I should try teaching it as a one-semester course and teaching it out of my book, The Limits of Freedom of Contract, not the virtues of freedom of contract, the limits of freedom of contract, dealing with highly sensitive issues, commodification, paternalism, et cetera, which I cut straight to the heart of interdisciplinary debates over the role of markets and contracts and so on. But that's not the way I taught it, and I feel guilty that I didn't teach it that way.
Thank you. Well, we have to wait only until after the coffee break to hear more about Marty's contributions. But for now, before we wrap up, any final thoughts that anybody would like to offer on the panel? No, we're all good. Well, thank you all for getting us started in a really great way, in particular our panelists, and also the objects of their attention, because they got us started in a really great way and launched us to where we are now. So we have a short coffee break, 15 minutes. We're back here at 2:45 with our next panel. See you all then. Oh, Lauren, I did not see you. Hello.
Just terrific. Such a great
Yeah, we were hoping that this would happen a little. Hopefully people will warm up so that we can share more of these actual All right, so if you had a look at the program, you will not only see what great things we have coming up next, but also that it's relatively tightly paced, so our breaks are somewhat on the short side, and my job in part is to make sure that we all stay somewhat on schedule so that the next somewhat short break will be at least not shorter than it already is. But without much further ado, I'm going to lead over to the next panel, but not also without saying that in addition to all of us who've masterminded the conference and have kind of brought people together, and all the colleagues who have agreed to be part of the project, there are of course lots and lots of other people who have helped in organizing this, and I should have said that at the outset. That includes our amazing event staff and a whole bunch of other people who've been instrumental in making this possible, but I do want to give in particular a shout out to the library, to John Medvis and his team, because actually we wouldn't have been able to have such easy access to all of the scholarship that many of us looked at had there not been a whole team of people in the library who actually created a repository of every single person who was once on faculty and compiled the quite voluminous writing that all of those people have generated. So thank you, and a hand to the library. And this is probably a really amazing resource that we should think of keeping track of and also making available to other people who might be interested in taking the journeys that some of us have taken. But now I am absolutely delighted to introduce our next panel. So we'll begin with Professor Jim Phillips, who is going to give us a perspective on Professor Emeritus Dick Risk. From there, we'll go to Professor Kent Roach, who will speak to us about someone who's come up already a couple of times, and that is Professor Marty Friedland. And then last but certainly not least, Professor Brenda Cosman, who will talk about Professor Alan Mewett. So 10 to 15 minutes for each. I'll try and wave a little 5-minute thing at each of you when we're getting close to the time. And with that, Jim, over to you.
Thank you. If you need something to, that's your piece of paper you wave at me when I've got 5 minutes left. So thank you. It's a profound pleasure and honor to say a few words about Richard Charles Bosworth Risk, which I've entitled my remarks, Maker of Canadian Legal History. It's appropriate, I think, for me to be saying this because not only because we taught Canadian legal history on many occasions, but mostly because perhaps apart from members of his family, I'm the only person who knows what the B stands for in RCB Risk. It's obvious what the R stands for, and while not obvious, the C stands for Charles, not particularly interesting. But when people asked about the B in RCB Risk, he would always coyly tell them to work it out. Red and White Rose, York and Lancaster, and for the slower ones, he would add End of the Plantagenets, Henry Tudor, etc. Dick knew his English history, but he left his indelible mark on Canadian legal history. So I'm going to talk about two things today. One is to talk generally about Dick's contribution to the development, the origins, in fact, and the development of Canadian legal history. And secondly, I want to talk about one of the pieces he wrote. He wrote many, many articles. My paper is actually about two of those pieces, but I've realized both that there's a limited amount of time in the presentation, so I'll only talk about one. And the one I've chosen is also particularly relevant to the theme of the law school history, looking forward, looking back. So when Dick began working in the area of Canadian legal history in the early 1970s, to say that the top subject was in its infancy would be a gross exaggeration, whatever. Dick himself acknowledged this in an article he published in the Dalhousie Law Journal in 1974 entitled A Prospectus for Canadian Legal History. Canadian legal history, he told us on that occasion, has been greatly neglected by professional historians and academic lawyers. In his pithy way, he added, quote, "We have not even accumulated and organized most of the major facts, let alone thought about them." A colleague and I were recently asked to write about, quote, 50 years of Canadian legal history for the 50th anniversary of the same Dalhousie Law Journal that Dick had written that article in 1974. And we emphatically agreed with what Dick had said then. We called the scholarship on Canadian legal history in the common law provinces. This is actually not entirely true in Quebec, but in the common law provinces, we agreed with Dick, and we called the scholarship at that point, before Dick started, almost all of it written by judges, quote, in equal measure antiquarian, descriptive, and hagiographic. In the 1970s, Dick, a teacher of real estate law and prominent in development that led to the passage of Ontario's first Condominium Act in 1967, took on the Herculean task of changing all that, and he amply succeeded. As Hamar Foster, one of the leading legal historians of British Columbia, observed in a festschrift published in Dick's honor some 25 years ago, which I was one of the editors of, quote, Dick deserves a goodly share of the credit for transforming Canadian legal history, quote, from professional pastime to academic discipline. His ability to do this was enhanced by a few other people who joined him, and by, at that time, the then Attorney General of Ontario, the late Roy McMurtry, the late great Roy McMurtry, who played on the same U of T football team as Dick in the 1950s, and who, as Attorney General of Ontario, founded the Osgood Society for Canadian Legal History. So Dick very much then the pioneer. Dick's work was all about post-Confederation Canada. Dick's later work, I say, he began with a number of articles in the 1970s about Canada West and about the relationship between law and economy in that province, now Ontario. But after he'd done that, he turned away to post-Confederation Canada, and he progressed in various ways through three distinct subfields of Canadian legal history: the emergence of the administrative state, the distinctively Canadian approaches to Canadian legal thought, and Canadian constitutional history, although a number of his articles combined elements of at least two of these subfields. So in the next section of my paper, I won't talk about it here, I talk about Dick's article on the origins of workers' compensation in Ontario. He was very much a pioneer in this, and he was able to use this particular story to talk about both the obvious change between an entirely court-based adjudication process and the assignment of fault, etc., into what we have now, what we still have, which is a regulatory state and an administrative agency, etc., etc. And for Dick, this was very much symptomatic of the move away from the 19th century faith in the common law as the embodiment of individual autonomy and laissez-faire, and into beginnings of the 20th century approach of collective responsibility, social responsibility, etc. So, and that particular article is also wonderful because it combines both sort of straight doctrine, things like the fellow servant rule and the rise of contributory negligence, and then this latest statutory reform, with actual empirical work in the court files of the Ontario Supreme Court, looking at cases where people had litigated in relation to workplace injuries, and then into the workings of the commission, in which he thought that the particularly important person was the commissioner, Chief Justice Meredith, former leader of the Provincial Conservative Party, who himself said, this is just social legislation. This is a new way we have to go about thinking about dealing with our particular social problems. So it's a wonderful article by Dick. But rest of my time, I've chosen my second piece of Dick's work to highlight in large part because it was a major original contribution to the history of this law school, emphasizing the fact that this law school did have a history before 1949. Indeed, in the very first paragraph of an article published called The Many Minds of W.P.M. Kennedy, Dick said that the study of Kennedy and the pre-Cesar Wright Law School would serve as, quote, a chastening reminder to contemporary law schools that they were not the first to embrace the interdisciplinary study of law. I should say that Dick and I used to make a little joke back in 1999 on the occasion of the 50th anniversary of modern legal education at the University of Toronto, that really there was a law school, you know, before 1949, and perhaps the law school should pay a little more attention to that. But I'll leave that aside. So I couldn't resist saying that 25 years later. So the article on WPM Kennedy, rightly described by Kennedy's biographer Marty Friedland as, quote, brilliant, is both about Kennedy, the scholar of Canadian constitutional history, and Kennedy, the dean of the law school. Both were unlikely careers for Kennedy to take up, because Kennedy, when he first came to Canada, was already a serious and well-respected scholar of early modern, I have to put in the early there, of early modern, i.e. Tudor, English classical history, church history, when he came to Canada to first teach at St. Francis Xavier College. He moved to Toronto and then became interested in Canadian constitutional history. And so just get this, in 10 years, between 1914 and 1924, Kennedy published 5 books in order, quote, Parish Life under Elizabeth, quote, Studies in Tudor History, quote, Documents of the Canadian Constitution, quote, The Constitution of Canada, An Introduction to Its Development and Law, and finally, Elizabethan Episcopal Administration. So it's daunting, I think, for most of us modern people to imagine that we could possibly have that kind of range. So Kennedy, of course, was not the only Canadian law teacher to start in a field other than law. I'm one of them. There are many other of my colleagues here, and then switched to law. But he was surely the first who didn't actually ever have a law degree. So I discussed Kennedy's constitutional history, making the point that this is a very different kind, more of an interdisciplinary kind of constitutional history than we think of as being a book about constitutional law or even about history. That is to say, today and for a long time, the writing on the Canadian Constitution has been writing about the division of powers. Well, for non-lawyer historians of the Constitution or non-lawyer students of the Constitution, the division of powers comes right at the end. Well, not quite at the right at the end, because we've now got to the Charter of Rights, but before that, right at the end, because you cannot divide powers among constituent authorities until you actually have given those constituent authorities powers to exercise. So Kennedy's constitutional history started off with the Quebec Act, went through the Constitutional Act of 1791, which created, okay, thank you. I could do this even more quickly than Kennedy. And for him, the most important event, and I've often said it is the most important event in Canadian constitutional history, was the Act of Union of 1840 and the responsible government that followed that. And only then could you think about a confederation in order to divide up those responsible government powers and to solve the problems of the constituent elements of the two east and west, Ontario and Quebec sides of the of Canada West, of the province of Canada. Okay, so Kennedy then had a very different approach in looking at Canadian constitutional law. Indeed, his book on the Constitution of Canada has only a very small part at the end dealing with the division of powers. Now, Dick was actually quite, when he wrote about Kennedy, he was both very praising of the fact that Kennedy took the long view of the Constitution of Canada, but also he was somewhat critical of certain things that Kennedy got wrong about the division of powers, because he was not actually a lawyer. And as many of you may know, Dick also wrote extensively about the judicial interpretation of the British North America Act in the 50 years after Confederation, the same period that Kennedy covered in his book published in 1922. And Dick was not averse to pointing out that the Kennedy's version actually missed out large and important parts of initially post-Confederation Canadian history, particularly the provincial rights movement and the way in which the Privy Council had in fact taken what was clearly drafted as a document with strong centralist tendencies and made it a provincial rights constitution. So in any event, the main point here is that Dick brought the history of the more general political and social and cultural history, including the religious distinctions that dominated the first half century of Confederation, into studying the Canadian Constitution, as well as the legal areas covered by his work on the division of powers cases. I will just be 2 minutes, you to stop looking at me like that. Okay. Now, the other part of Kennedy's, of Dick's article on Kennedy I should look at is the Kennedy Law School, which was in some ways a remarkable institution. Hard to Kennedy, I don't think, was actually appointed dean until 1943, but he was the head of the law school for 20 years before that. And he made the law school a truly interdisciplinary history. Now, Dick also weaved into his account of the Kennedy Law School an account of the Canadian legal realist movement, which Dick believed did happen. It existed in the 1930s, and much of it was centered on the University of Toronto Law School, or rather the Law Department of the political, whatever it was called. Nonetheless, looking at the people like Vincent MacDonald and Bora Laskin and Jacob Finkelman, who were part of the Kennedy Law School, or colleagues in other universities like Herbert Smith and Frank Scott of McGill, they represented our Canadian legal realist movement. Dick also pointed out the ways in which the Kennedy Law School was a genuinely interdisciplinary institution, and he has many good quotations from Kennedy's writing. He calls Kennedy's writing a small contribution to a major watershed in legal thought, a rejection of 19th century thought, an embrace of modernity, and a new understanding of the state. So all of these aspects were very much central to the pre-Caesar Wright law school that Kennedy has. At the end of the day, Dick actually concluded, I think probably rightly, that the problem with the Kennedy Law School, and this goes back to a conversation that came out of the previous panel, the problem with the Kennedy Law School is that the two topics, the law and the society, politics, everything else, were sharply divided. They were not integrated in any way. So students would literally they took courses in history and courses in English and courses in psychology or whatever, but they were taken in other departments. They were entirely separate, and then they would go to the law school and they would take courses in contracts and torts and constitutional law, but ne'er the twain shall meet. That, I think, was perhaps the failure, but I think more important is Dick's article on the attempt to make this kind of law school in a very unusual and unique law school at its time. So I'll leave it there.
Wonderful. Thanks so much, Jim. And now we'll go to Kent Roach.
Great. I'd like to thank the organizers for asking me to speak about Marty Friedland, my dear mentor and friend. And I thought I knew Marty's work pretty well, but as I worked on this paper, I learned something new, and I think it's relevant to future directions in legal scholarship. So first, if you'll indulge me, I'm going to talk a little bit about Marty as a criminal lawyer, and then, even though Ernie and Michael have stolen my thunder, I'm then going to talk about Marty's approach to legal scholarship and multidisciplinary. So you can't start talking about Marty Friedland without talking detention before trial. Detention before trial was written in 1965. It is still quoted in almost every major recent Supreme Court of Canada case about the right of bail. But for me, all you really need to know about detention before trial and about Marty is something that he reveals in his wonderful autobiography. He gave a young man in either 1962 or 63, Marty can elaborate, $50 so he could make bail. When he gave that money to the man, all the police laughed at him and said, "You're never going to see the money again." And indeed, the police were right. So for me, that is an anecdote that tells you everything that you need to know about Marty. Marty is a person who is first and foremost concerned about injustice. Now, that doesn't always mean that he has a full sense of what a theory of justice is. I certainly don't have a full sense of what a theory of justice is. But he has a concern about injustice. And I think that that is, I think, a particular calling of an academic lawyer. We have freedom from the profession. We have freedom, academic freedom. We should identify and call out injustice. Now, of course, injustice and justice are related. And Marty's work led to the Bail Reform Act in 1972. But he's also traced how, since that, we've crept more towards injustice as we put more reverse onuses, as we still use money bail, as the number of people who are presumed innocent but imprisoned increases. So again, it is injustice. Next, I want to move on to Marty's true crime trilogy. And these are about what I would call miscarriages of justice. They're not even necessarily about wrongful convictions, let alone the American concept of proven factual innocence, which, by the way, is contrary to the presumption of innocence. And of those three books, it is not a coincidence that of the three, it is the poor 22-year-old Jewish immigrant to England, Israel Lipsky. He is the one who hangs. The other two, Valentine Shortis, an Irish immigrant with rich parents and connections with the Governor General, that's always a good thing to have, doesn't hang. And Patrick, the New York lawyer, doesn't hang. And if you read those together, I would also say, and this moves into multidisciplinary, it reveals a Canadian advantage in comparative law. We know the Americans, perhaps too well. We know the Brits. We are by nature comparative lawyers. And if you read Marty's books together, they are something in a great study in comparative law. Let's move on then to multidisciplinary. Detention before trial could have been written by a criminologist. It comes out at the same time that John Edwards is starting the Center of Criminology at the University of Toronto. It is a work of criminology. As Marty again says, and I'm sure copies are available, it was a risky thing for him to do as an untenured professor to do an empirical study. I think, a lot of us, including myself, we don't do those empirical studies. It's risky, it requires money, and it is really quite difficult. So Marty is a risk taker, both with the $50, which I should add, in 1962 is a lot of money for a young professor with a young family. It shows where his heart is, right? I really don't know what the family said, or if you even told them about it. And then I agree completely with Ernie, which doesn't always happen, and Michael, courts and trial. This was the first law book I ever bought. It's not surviving so well. But if I had to trace a history of where we are now, it really, I think, starts with courts on trial. And here you see Marty having a broad multidisciplinary approach. Yes, there are philosophers. Yes, there are economics, but there's political science, history, a mathematician, a sociologist, and Marty apologizes in the preface that he couldn't find an anthropologist. Right? So it is a very pluralistic view, and it also has a degree of humility, right? Because he says, this isn't interdisciplinary. I'm simply bringing in people from the rest of the university to the law school to talk about law, because we can learn something from them. From there, he goes on to sanctions and rewards, another collection. And again, he brings in all kinds of people, professors of business, management studies, sociologists, and so forth. And then in Rough Justice, he brings in practically the entire English department, including Northrop Frye. Right? So every chapter in Rough Justice is written by a member of the University of Toronto's English department. So Marty, in his bones, knows the importance of the entire university. Right? Why? Well, he serves for a long time as the head of the Manuscript Review Committee at U of T Press. I remember, seeing him working on that during his early days. He goes on to write the history of U of T. So this wouldn't be a U of T event unless we had a little bit of Osgood bashing, and we haven't had any. So I'm going to start. And I'm going to end up on two things. The first is, Marty and Harry Arthurs are classmates, friends, and they both agree and they both do an elevation of legal scholarship, right? And they both move towards other disciplines, right? But what I want to suggest is there are some subtle, but I think important differences between Marty's approach to multidisciplinary studies and that of the Arthurs report in 1983, okay? So the first is the Arthurs report is about humanities and social science. That's very important, but it's not the entire university. Marty's casebook, his criminal law casebook, brings in forensic medicine, brings in all of the science that is involved. Because as a criminal lawyer, he knows that the legal profession is multidisciplinary. That's what expert witnesses are for. And in this book, he uses Isabelle Le Bourdais' book, kind of exposing a miscarriage of justice, exposing that the expert witnesses may have been wrong. And she couldn't even get the book published in Canada when she started, and some people at that time called for her to be prosecuted for contempt of court. Marty includes it in his book to kind of introduce the possibility of error. So, let's look at the entire university, whether it's the business school, whether it's the medical school, as well as humanities and social science. There's a lot of humanities and social science, but it's not just with the kind of laser focus that Arthurs has, that's developed into this idea that in a lot of elite law schools, the meta disciplines are economics and philosophy. Let's look at the entire university. And second, Marty never, I think, had this idea that there's inherent tension between academe and profession. He worked with G. Arthur Martin, moonlighted, if you will, on the first Truscott reference. They lost. It was left to his daughter Jenny, who worked with James Lockyer, who eventually got justice for Stephen Truscott. And throughout his career, Marty has been consulted and worked on commissions of inquiry and is engaged with the profession. When you go out with Marty, and he believes in experimental learning, I've been in Attica prison with Marty. He brings the students into Attica prison. He talks to everyone. He's interested in everyone whose job is part of justice. Last thing I want to say, and this is what I really learned in doing this research. Right now, we're all talking about AI. Chris talked about AI. Marty can adjust. He adjusted much better to me than computer learning, and he's a bit of a whiz at it, at least compared to me, which isn't saying much. But anyway, he wrote a book in 1975, coming out of, I think, just a year he spent at the Law Reform Commission of Canada before he came here to be dean, called Access to the Law. And to me, that's a book that's very relevant to what AI can or cannot do with the law. Because the message of Access to Law was, as Marty said, lawyers should not be the high priests who are the only ones who can find and interpret the law. So he looked to libraries as a place where everyone could get legal advice. Now, perhaps, and some of my colleagues have written about this, AI also allows that access to law. But he also talked about the importance of linguistics and psychology in reducing complexity in the law. And to me, Marty tried to resuscitate this work in, I think it was 2002, after he had officially retired, but of course Marty never has or will retire. And I think it was interesting that he didn't look to the Law Society for funding, because he has this passion about protecting against injustice and helping the ordinary person, like the guy he lent $50 to, because and a sense that the law should be for all of us, not just for the advantaged. So thank you very much.
Thank you. Thanks very much, Kent and Brenda.
Thanks. I'm going to try and do this through my mask. So Alan Mewett was one of Canada's most distinguished legal scholars in the field of criminal law and evidence. His iconic status extended well beyond academia. It influenced judicial reasoning, legal education, and public policy in Canada. He quite literally wrote the book on criminal law, co-authoring what I believe to have been the first Canadian criminal law textbook, shaping the very foundation for modern Canadian criminal thought. He was brilliant. He had a blistering wit for anyone who knew him. Now, I didn't know him well at all. I certainly didn't know him as well as many of my colleagues, including those on which I'm sharing the panel. He did teach me evidence in 1986. It was a thing of great beauty. He would come into the class, the old moot courtroom that doesn't exist anymore, thank God, without a single note. He had not a single note. He would hop up on the table at the front, and he would deliver the most articulate and entertaining 2-hour lecture in perfect sentences and paragraphs. I found him as a student to be unbelievably intimidating. That blistering wit just felt like it could get turned on you at any time. But he was a total rock star of a professor, although, in a kind of old school British style. So by the time I then come back to the law school in 1999, Alan was retired, but he was still teaching. I never got to know him very well, other than to really say hello, particularly when he was parked on his bench at the entrance to the law school, which is now actually his bench at the entrance to the law school. And so I'm not a criminal law scholar, and so one might readily ask, what am I doing here? There are others who would be better placed to discuss his contribution to criminal law. Kent, Hamish, Martha, Jim was a close friend. So what am I doing here talking about Alan's work? Well, I'm doing so very narrowly. And so several years ago, when Canada was marking the 50th anniversary of the decriminalization of homosexuality that had happened in 1969, a group of left queer scholars and activists, who I often refer to as queers against speed bumps, because they hate everything. They've never seen anything that they liked. They banded together for an anti-69 campaign, because really, the decriminalization of homosexuality in 69 didn't really do anything, and it was terrible, and it made things worse, and it was just a bad thing, and everyone should stop romanticizing it. So I got mad, which is basically the basis for almost everything I've ever written. It starts when I get annoyed. And so I organized an anti-69 volume for the UTLJ, trying to defend the importance of the amendments in 1969, not just because it poof made everything better, but because it actually created enormous space for things to subsequently become better. And as I was researching this, I actually then came across an article that Allen had written in the UTLJ in 1962 entitled Morality and the Criminal Law, while he was still teaching at one of those other law schools. Allen argued, quote, that the criminal code is not and should not be a moral code with criminal sanctions attached. And hiding in plain sight, amongst various other things, was an argument that taking morality out of the criminal law required the decriminalization of homosexuality. Now, the 1960s were very heady times for debates about morality in the law. The 1957 Wolfenden Report had recommended the decriminalization of homosexuality in the UK, as well as some modest legal reforms to prostitution laws. The report argued that the function of law was not to enforce private morality, but to prevent harm. So the beginning of a shift from legal moralism to harm prevention. And it laid the groundwork for the eventual decriminalization of homosexuality in England and Wales through the Sexual Offences Act in 1967. It also sparked, as many of you will be familiar with, a major legal and philosophical debate about morality, law, and individual freedom. In what would become known as the Hart-Devlin debates, Lord Devlin opposed the recommendations of Wolfenden, arguing that society had the right to enforce morality through law, even in private matters, because shared morality was essential for our social cohesion. In his view, immorality, like homosexuality and prostitution, threatened the very moral fabric of society. H.L.A. Hart countered that the law should not enforce private morality unless it caused harm to others. In his view, moral disapproval didn't justify criminalization. Okay, enter Allen, stage left. He didn't directly engage in the Hart-Devlin debate. His writings were very much part of what I would have called the emerging zeitgeist of the moment, aligning with the spirit of Wolfenden and Hart's position on the relationship between morality and the law. In fact, several years before the UTLJ article, Allen had written not only on the appropriate scope of the criminal law, but also quite specifically on how sexual offenses in the criminal code should in fact be reformed. He argued that morality needed to be removed as the basis for criminalization, including in particular with sexual offenses. These prohibitions, he said, and I quote him, were often based on the horror of anything which is not generally done, that is, which is not normal, even between females and males. He argued that instead of morality, criminalization for sexual offenses should be based on 4 grounds, which actually have echoes of Wolfenden: violence or fraud, corruption of youth, exploitation of the weak, and violation of the rights of others. And he proposed reforms to the criminal code accordingly. And his proposals for reform included, amongst various other things, the decriminalization of homosexual acts between consenting adults done in private. Then in the UTLJ piece, several years later, he expanded on the justification for why morality should be removed from the criminal code. He focused in particular on offenses premised on moral corruption. That is, where the criminal law sought to prevent the moral corruption of others. And this corruption of moral offenses included a mix of sexual and non-sexual offenses. He focused in particular on gambling, alcohol, drug use, and so-called illicit sexual practices. The language, reading about anything to do with sexual offenses and sexuality in this moment in time, it just feels like you've sort of dropped back into the 19th century in terms of some of the language that is being used here. So illicit sexual practices. Now, he didn't argue that these should be all decriminalized. Instead, he distinguished between offenses that only sought to prevent the corruption of others from offenses that sought to protect the public from what is, quote, outrageously offensive or indecent. In his view, things which are publicly offensive may be crimes, not because they morally corrupt, but because of their general social offensiveness. The essentially public nature of things like gambling or bawdy houses, which we might see now as public nuisances, should be understood then not as preventing corruption, but protecting the public from things that are outrageously offensive or indecent. He turns again to the Wolfenden Report on the function of the criminal law, which was, amongst other things, but Wolfenden said that the function of the criminal law was to preserve public order and decency, to protect the citizen from what is offensive or injurious, and to provide sufficient safeguards against exploitation of others. So the challenge, he said then, accepting those as being the functions of the criminal law, he said the challenge is what do we do with these 4 areas? Drinking, gambling, narcotics, and illicit sexual practices, which he wonderfully described as indulgences that are generally desired. He didn't mince his words. The law should not be trying to prevent these indulgences, but rather their undesirable consequences from engaging in them. So he then talks about, he has long discussions about adultery and fornication and homosexuality. Again, this is the language of the moment. And say we shouldn't be trying to prohibit these illicit sexual practices, just their undesirable consequences. There was he expressed some ambivalence around the question of homosexuality. He said, well, you know, we don't really understand. There's a lack of understanding about its potential harm. He says, I'm not at all sure that one can talk blandly about homosexual activity between consenting male adults when so little is known about the psychological effect of consenting to the specific act, but perhaps not realizing the consequences. Also very much reflecting the language that was in the Wolfenden report. But he says, on the other hand, look, there's lots of other things that the criminal law does not prohibit, like fornication. He says, you know, consenting to a single act of sexual intercourse by an adult female may have disastrous consequences for her and ultimately for society, but we don't prohibit it. So the same consideration, he says, should be extended to other deviations from normal sexual intercourse. He concluded that given that homosexual acts will continue regardless of their criminal status, and that they do not have morally harmful effects, although he wasn't so sure about that, the law should be more concerned with controlling and limiting the means for indulgence than with declaring the indulgence itself to be illegal. He ended his essay as he started it: the criminal law should not concern itself with citizens' moral corruption. So, you know, what to make of all of this? So, as a defense of so-called illicit sexual practices, Mewitt's position might, by contemporary standards, seem to leave a little bit to be desired. He spoke of, and in fact, in his proposed reforms of the criminal law dealing with sexual offenses, he still spoke of chaste character, of offensive and indecent activities, to the very category itself of illicit sexual practices, which he admitted as being problematic, but he couldn't think of anything better to use. Okay. But so his language really had a sort of considerable moral hue to it at the time. So did his language around homosexuality in particular. Homosexuality in his writing was unquestionably undesirable and a vexed problem, even in relation to private acts between consenting adults. So one could look at these writings and say, you know, well, this is pretty contradictory. It kind of promotes the very moralism he claimed to be against. And others, including the Queers Against Speed Bumps, of whom I speak only with derision, might read it as a kind of deeply homophobic text revealing the deep structures and discourses of homophobia of the day, or even anti-feminist texts concerned more with the failure to punish women than to protect them. And I would say, as I always say against these people, this is not how these texts should be read. Now, Allen absolutely was deeply entrenched in the ambivalent and at times contradictory discourses of the day. Many have since looked at what the Wolfenden report actually said, and the extent to which the Wolfenden report itself was still very based in an enforcement of certain kinds of morality. In fact, many have pointed out how the Wolfenden report itself was no statement around sort of, you know, gay liberation. It reflected many, many highly negative attitudes towards homosexuality. In fact, the establishment of the committee, it was appointed by Home Secretary Sir David Maxwell Fry, who, amongst other things, mostly he just wanted prostitutes off the street. But he'd also been quite embarrassed by some high-profile homosexual scandals in the US. But he regarded, quote, homosexuals in general as exhibitionists and proselytizer and a danger to others. So this was the man who, you know, appointed the Wolfenden report commission. This was a time, despite the fact that the report was the beginning of a shift away from the vilification of homosexuality, it was that, just the beginning, and it was a time of deep, rampant public homophobia. So this was the context in which Mewitt wrote these 2 articles in 1959 and 1962. So some of the language that he was using at the time simply reflected what was at the time the dominant but progressive discourse. He would go on to publicly support the decriminalization of private homosexuality in the Canadian debates. He'd appear before the Standing Committee on Justice and Legal Affairs while Parliament was debating Bill C-50. When asked about, now actually most of his submissions actually involved the abortion reforms, but when asked about his opinion on the proposed reforms dealing with homosexuality, he just said, "There has not been a prosecution in Canada for buggery between consenting adults in private since the revisions in 1953. My view is that it is desirable that the criminal code conform with actual practices." Now, he didn't argue for a broader decriminalization of buggery or gross indecency. He didn't argue for a harmonization of the age of consent for these activities. He didn't critique the distinction between public and private. In fact, he would go on to be a very ardent defender of privacy. He simply stated his support for the partial decriminalization of homosexual acts that occurred between two people in private. And many would suggest that this was part of the problem of 69. I would say counter to that, this is actually what made his writing so extraordinary for the moment, because no one else in legal academia was writing anything like this at the time. No one else touched anything like this. And in the paper, but I won't talk about it here, his writings in general around sexual morality and the criminal law were actually quite remarkable for their, I would say, both their radicality and foresightedness, and can continue to help us think about how we regulate sex and sexuality and sexual offenses today. I would argue that a lot of what he argued in favor of remains uncompleted today in the context of the criminal code. And let me just end with a quote from the obituary that appeared in the Globe and Mail. So he was described as a legendary law teacher whose erudition, laconic humor, and occasional acerbic criticisms made his classes compelling for generations of law students. This is all very true, but anyone who knows him has to wonder why the word occasional was added in front of acerbic criticisms. So I'll end there.
Well, many thanks to all three of you for this really rich tapestry of contributions. I said earlier that I don't know, Marty, whether you feel provoked to jump in, given that you are actually an object of a paper and here with us. You can ruminate about this and come in at any point, so and we will just slide you in, so to speak. But so the floor is open. And speaking of sliding, so again, if anybody prefers to be anonymous, there is Slido. You can use that technology. And the same goes for our participants online. And I will make an effort to bring your questions in. And if you would also just briefly introduce yourself to everyone.
Thank you. My name is Peter Grant. And last year I taught a course here at the law school called Broadcasting and the Internet. I'm a communications lawyer. And the reason I came here today was that I owe my entire career to Dick Risk and John Willis. And it's an interesting story in itself. In 1965, I was in second year law and decided for some reason to take a course called Legal History, offered by Dick Risk. I think that was the first year he offered it in '65. Nobody knew what the heck the course was about. We sort of thought maybe this is going to be about early canal law or something. But no, Risk opened the course and he said, what I want you to do is an essay on some little known regulation or something and tell me the history of it. How did it come to be, and etc. So I'm thinking, oh, well, I've got to look around. What sort of regulation should I look at? And by coincidence, a Royal Committee or Commission on Broadcasting had been issued just 3 weeks earlier. It's called the Fowler Committee, and it talked about the Canadian content regulations of the Board of Broadcast Governors quite critically. In fact, later the government, as you may know, created the CRTC to replace the Board of Broadcast Governors and so on. Okay, so I thought, well, that's an interesting topic, but because I have this little report that I can work off. So I worked up the essay and handed it in at the end of term, and Dick Risk gave me an A, thought it was a great little work, and he handed it to John Willis and also Albert Abel, both of them interested in in administrative law. And through Albert Abel's work, The essay, as amplified, later got published in a little-known academic journal called Canadian Public Administration, published by the U of T Press. And so a couple of years later, I get a little message from the U of T Press. Here are 25 reprints of your article. So I'm wondering, what am I going to do with this? So I thought, just for laughs, I'll send a copy to the new chairman of the CRTC, a guy I'd never met, Pierre Junot, and enclosed, please find reprint of my essay on Canadian content regulations. I'm interested in further research, I said. So I get a call the next day back from his secretary. Mr. Junot will be in Toronto and wondered if he could have coffee with you at the Royal York Hotel. Oh, so I go up to the law school, and who do I meet but John Willis? I explained to him the situation and says, what do you think I should do? Now, you might remember Willis was absolutely fascinated by how do administrative agencies really work. And he says, well, you've got to go up there, but what should I do? And he said, ask for money. And I said, what do you mean? How much should I ask for? At that time, I was articling at McCarthy's, so I had my own salary. And he says, well, ask for enough to hire a couple of law students for the summer. And they can go up to Ottawa, Xerox everything, interview everything. Wonderful opportunity. So I thought, okay, well, I've worked it out. How much money would it be to hire 2 law students for the summer? $5,000 should do it. So I went for coffee with Pierre Junot, a guy I'd never met. His research director was with him. And I said, I'd like to do further research. And I asked him for $5,000. And I came out of the meeting with his assurance, you've got $5,000. And believe it or not, ladies and gentlemen, that started my career in communications law. It was all based on Dick Risk and John Willis. Thank you.
All right. Anyone else who would like to jump in and on the bandwagon, or any interactions between all of you? Are you, Kent, I saw you nodding a few times. Were you on board with Brenda's take on Mewett?
Yeah, I mean, Alan also taught me, and he was a legendary teacher. And I think, you know, he was concerned about a lot of those issues. And he engaged, you know, there was a little bit of a difference. Is Alan as a person was, I think, even more lively than Alan on the page. And so, you know, maybe some of the things that Brenda was saying, I would also factor that in. But and I also didn't know that he testified before the committee, and I think that that's also very important and very courageous. And so I look forward to reading Brenda's paper that will tell me more about that, because I didn't know about that. And of course, Alan's text, which is amazing, was co-authored with Morris Manning, who is also the person who represented Dr. Morgenthaler and Rebecca Cook and others know about that. And so, you know, I think of Alan and Marty and John Edwards as you know, really you know, this incredible criminal law team that we had when I was a student here, and you know, interested in multidisciplinary. John with his work on the law officers of the Crown. Marty, I've talked about his interest in multidisciplinary. Alan was the editor of the Criminal Law Quarterly, and you know, one of the things that when he asked me to take over for him, the first thing I did is I went back and I read all of Alan's editorials, and you know, seeing him engage with the issues of the day. And you know, some of those editorials have been cited by the Supreme Court of Canada, and I know that, you know, I mean, they come around every couple of months. You got to write write one of these editorials. And so I also appreciate that. And Alan was, he was a good editor, right? He wasn't an editor who would judge the paper that he would have written. He was an editor who tried to improve your work, but took the kind of thesis and the orientation of that work as his starting point. So I have fond memories. I mean, it was a wonderful criminal law team that we have, and I think the practice of criminal law is really important, and I think U of T has in many ways maybe punched above its weight in terms of producing some of the leading criminal lawyers, and I very much hope that continues in the future.
Thanks, Kent. Jim, did you want in on anything?
Well, I mean, I'm tempted, of course, always to talk about Alan Mewett, who is a wonderful friend. I was not a student at U of T, so Alan never taught me, but he was very open and friendly when I joined the faculty, and he was a wonderful friend to me. He was best man at my wedding. I was one of his co-executors. So I have all these great memories. We used to sit on the bench together, the Alan Mewett bench, smoking. We were notorious for that. But I think the thing I remember most about Alan was he was very uncompetitive in everything he did. So he was very erudite, but incredibly uncompetitive. And this got shown up most of all in Scrabble, because we would play Scrabble a lot, and Alan always lost. Now you wouldn't think this. You wouldn't think this was the case, because in fact Alan could do the New York Times crossword in 5 minutes flat in the morning, right? So, but the problem was Alan would come up with these sort of very obscure 6-letter words, 3 vowels, 3 common consonants, all scoring 1 point, right? So he put this word down that you'd never heard of, and then of course sometimes you challenge it, but there's no real point in challenging it because it would turn out to be a real word. But he'd score 7 points because one of the letters would be on the double letter score, double square, right? Whereas, I was much more competitive, so I knew the whole point of Scrabble was not to come up with clever words, but to get the X on the triple letter, and then the whole thing on the double word score. So to put down, and if you could do that both ways, right, you could put down 2 tiles and score 63. And he's nonsense. Anyway, I remember that about him. He was charming in his lack of competitiveness, and he also complained about my indulging myself in sports and bike riding as leaping about. Why are you leaping about like that?
Yeah, I have fond memories too of Alan as a professor. He was terrific. But I want to come back to detention before trial and Marty, and say just to almost double down a little bit on the significance of that work, because it wasn't just that it was interdisciplinary, but that it was empirical. And Kent, of course, identified it as such, but it was so far ahead of its time. Interdisciplinarity wasn't that far away in North American law schools, and of course Marty played a role in bringing it to the fore in Canada at U of T. But empirical work lagged. It took a long time for us to start taking facts more seriously, which is something I know Michael drills into his students, take the facts seriously, but yet we didn't. There was really important works in one of the areas I'm interested in, corporate law, where the writers would make assertions of, well, of course, and people never go public with this particular provision in their articles of incorporation. And then people started looking at, in fact, they did. So Marty, I think it's not just that it was interdisciplinary, but that particular kind of interdisciplinarity was really ahead of its time. And I guess if there was a complaint I would have about it, is that you didn't get us doing that sooner, Marty, mimicking you a little earlier. But I'll also close with one final recollection that I'm sure I remember from first year crim. I also had Marty talking about his dedication to empiricism, including a group of you getting together, I think with an OPP officer, or maybe Toronto police drinking and blowing into a breathalyzer, and seeing at what point it was unlawful. What point did your blood alcohol become unlawful? And I remember Marty saying, I'm not much of a drinker, so I felt completely out of it, and I blew under. And I said, there's got to be something wrong with this. But that's Marty's. He's experimental as well as observational.
Thank you. So we'll go to...
And we better not tell Shirk that I'm pretty sure that went on to the Shirk grant, right, Marty?
We'll go to Hamish and then Rebecca, and then maybe go back to the panel for a bit, and I'll still coax Marty to maybe add something, or maybe not.
Thank you. My name is Hamish Stewart. I'm a professor here at the law school. I just wanted to say a couple of things about Alan Mewett, and then I have a question for Brenda, which is related to what she said. I knew Alan fairly well, not as well as some other people in this room, but I knew him pretty well, and I really was moved by everything that people said about him just now, because it was all true. I was not his student, but I taught evidence for the first time in the spring of 1995. And in the fall of 1994, I asked Alan whether I could sit in on his lectures to get some sense of what this subject was all about. And he very graciously allowed me to do that. And his lectures were just as Brenda described them, except she left out one detail which I would like to add. He used to draw these completely incomprehensible diagrams on the board. And he would go back and adjust them as class went on and add little bits and curlicues to them. And I'm sure they meant something to him. But no one in the audience could figure out what they meant. And I was certain that this was a sign of great genius, but I wasn't quite sure how to cash that out. So I just wanted to add that detail to, I hope you remember that as well, Brenda, because I was really struck by that.
You'd have to hop off the desk to go do that. Yeah.
Yes, he did
He'd
have to hop off.
on the
He did
desk,
have to hop
yeah.
off the desk to do that. I was listening to his lectures in the Bennett Lecture Hall as it then, I guess it still is the Bennett Lecture Hall, though it's a little smaller. There may not have been a desk for him to sit on, so that may have been. Anyway, the question, Brenda, is this. I know that you're trying to describe his work in the linguistic context of its time and the discourse of the time, and I totally get that. So this question may just be irrelevant to that project, I'm not sure. But I always found the framing of this debate of the Wolfenden report and this Hart-Devlin framing a little weird in terms of morality versus not morality. Dworkin said that the problem with Devlin was not that he thought morality mattered, but what he thought morality was, that was the problem with Devlin's view. And the idea that criminal law should be a mode of harm prevention is also a moral view. It's just a very different one from the one that says, I should get you to stop, you should be prosecuted for what you're doing because it bothers me, even if I don't have to look at it. So I don't know whether there's anything in Alan's, those particular pieces of Alan's that you referred to, I actually have not read, or at least not recently, but I wondered whether there might be something about that in them. I don't know, it's just a suggestion, because it struck me that he might be open, he might have been open to reframing it in this Dworkinian way. Of course morality matters, but what matters is what you think the content of morality is for the purposes of the law. And of course for Dworkin it was a kind of a constitutional democratic morality as opposed to this more whatever Devlin thought it was. So that's just a question.
Great. So Brenda, you have a little moment to think about that while I go to Rebecca. And it looks like things are getting going here. So we'll go back to Brenda, then the panel, after Rebecca's question.
It's a question for Brenda. Interesting, very insightful on Alan's scholarship on buggery and the Wolfenden Committee report. And I'm wondering how he used, if at all, any social science or public health evidence in the debates around the decriminalization of sodomy. Certainly in the abortion context, particularly in Canada, the Badgley Committee, which was really absolutely instrumental in the Supreme Court's decision in Morgenthaler, was really instrumental. But I'm wondering whether Alan was working at a point in history where social science, public health, didn't have the influence on decriminalization of sodomy as when the Badgley Committee was written, and how, I think it was 69, and then over a decade later, it had a huge influence in the Supreme Court's decision.
All right, Brenda, you're up. And then either of you, Kent or Jim, want in on any of it, always the panelist's privilege.
So Hamish, I would say, so Alan, I would say he was very rooted in the moment of there's this shift from this idea of legal moralism to harm-based. And then, eventually there's a return to a kind of, neo-legal moralism, but he was really located in that moment that some things were morality and some things weren't. And he said, he did talk about, look, there's a lot of things that are in the criminal code that are immoral, but they're not in the criminal code because they're immoral. So, murder, theft, all that. Like, sure, it's immoral, but that's not why it's there. So he was really part of that early attempt to move towards a harm-based approach, as indeterminate as that, subsequently became. But it wasn't really Dworkinian per se. It was really, some things may be immoral, but they have to also cause harm for them to be actually in the code. I'll go back and see if there's more there about the morality thing, but I think that it's very kind of pre-Dworkinian in that sense. And no, on the social science, not at all. Like really, a lot of his work was, particularly his submissions to the standing committee were all really based on the wording. They were he was lawyering, drilling down on the wording. And in his own work, there was only some reference to, only as much as the Wolfenton Report had said. Because the Wolfenton Report itself had said, we really need more research on things like homosexuality, and we really don't understand it, and we don't know anything about it, and there should be more research, and, maybe we should figure out how to discourage people from, being homosexuals, because that would be really good. But it was all sort of more forward-looking in terms of we should study that more. And he didn't really go there with that.
This is for Jim, actually. I wonder if we could talk about Dick for a minute. When I first came to U of T, I think the single most fortunate thing that happened to me was that I occupied an office next to Dick Risk for the first 6 months of my time here and the last 6 months of his time. And we talked every morning before we got down to work. And I remember fantastically interesting conversations with him about a range of things, but including Willard Hurst and the tradition of legal sociology in Wisconsin. And I had first thought that he was, I wasn't sure this guy would have anything all that interesting to say, and that was one of the most appallingly ill-judged perceptions I've ever had about anybody, because he was managed to be both very understated and very kind, but immensely erudite too. So I wondered if you wanted to say anything about those conversations which I had, and about the other directions in which his thought went.
Well, it's true that the Hearst School was extremely influential to Dick, and I think what we've got to remember here is that when he decided he was interested in legal history, he had no models. He had nobody to look to in Canada. Right? There are actually, as I briefly said, there are a couple of fine legal historians of the civil law, but there was really nobody in common law Canada, right? The principal writer on the legal history of Ontario is William Rennick Riddle, right? Who must have written 80 or something articles, short articles on the history of Ontario legal history, but every one of them short, and every one of them essentially an anecdote. So antiquarian description was all it was. So there were just no real models at all at that point. And I've never been sure whether it was taking a sabbatical at Wisconsin that created the interest, or whether he took the sabbatical at Wisconsin because he decided he was interested, and that was why he should go. Because Wisconsin at that point was definitely still seen as the center for writing legal history, beyond doctrine, right? And beyond the Constitution. Because again, one of the problems with American legal history is that every time you go to the conference of the American Society for Legal History, you can go spend all your time listening to articles about the 8th or 9th Amendment of the Constitution, not the American Constitution, but the Constitution, or you can go to papers on the rest of the world, right, and the rest of the discipline. So they have a peculiar view of these things. But Wisconsin was the place, as I say, in the Willard Hearst tradition of a kind of socioeconomic, a broad socioeconomic history, the idea of using law to unleash human endeavor and productivity. And also at that point, it had people like Bob Gordon, who started out his career, right? He's long gone from Wisconsin, but, and I think Chris Tomlins was also at Wisconsin at one point. So it was a place people went. Mitra Sharafi, the current president of the American Society for Legal History, or fourth income, anyway, she also still is, in fact, at Wisconsin. So he did a sabbatical in Wisconsin, and I think he just immersed himself in so many people who were Hearstians in one way or another. And then he came back, and that's why his first writings in Canadian legal history were those 3 articles on law and economy in Canada West, right? Because it's the same period, mid to late 19th century that Hearst wrote about, and it was the same kind of topics. Wisconsin was a state with a strong resource economy, and it shaped its laws in order to enable people better to exploit those resources. So he did wanted to do quite similar things to what Hearst had done for 19th century U.S. But what's also interesting about Dick, of course, is that fairly quickly stopped being a Hearstian, and, well, certainly stopped pursuing those same kind of topics. He really wanted not to do a Hearst version for Canada. He really did, so much of his career after that was about finding distinctive Canadian voices, both as legal thinkers, as judges and as lawyers. So he was very, that's what he liked so much about Meredith. He was the only, he wrote this remarkable article on John Skirving Hewitt, who was one of our major legal thinkers nobody had ever heard of. So he actually exposed for other scholars a great many of the great Canadian thinkers about the past that weren't simply derivative of US or the UK thinkers. So I could go on, but I think I'll maybe could stop at that point. Yeah.
And I mean, if I can just briefly add, because I took a couple of legal history courses from Dick, and by that time I'm not familiar with the first Hearstian, but he really had evolved, I think, into almost intellectual history. And certainly, when I was writing a research paper, I think it was on Clement or Lefroy. I think he also wrote on Lefroy, and it was really about getting into the mind. And I guess one of the things when we think about the future of legal education, if you look at Dick's, Marty, and Alan, you also see that things evolve and change over time. And I think that's one of the, real privileges about being a law professor here, is that you kind of have that freedom to evolve. And by the time Dick taught me, and I also took admin law from Dick, and Dick was a wonderful admin law professor. But again, I think why I like taking admin law from Dick is he taught it almost as intellectual history. And so he brought that even into his doctrinal studies. I don't know how he would teach real estate law, because anyway.
I wasn't sure whether either. But thank you for doing that, because I'm going to respond by reading a sentence which I missed out when I gave my presentation. So it says, when the late Blaine Baker and I, that is me, edited and introduced a collection of his essays published in 2006, following Dick's retirement, we referred to his work, as Dick's work, as, quote, a broad-ranging contribution to Canadian intellectual history, specifically a unique body of scholarship on the late 19th and mid-20th century Canadian legal mind. So you're absolutely right about that. That's what he was. He was primarily an intellectual historian, which I am not, but nonetheless, I think we gained a lot from our many conversations over the years. I do more empirical, fact-based, more socio-legal history. But, yeah.
So I have a couple of questions in my kind of editorial conference organizer mode. So one of them is for Jim and Kent, and one of them is for Kent and Brenda. So for Jim and Kent, both of you talked about interdisciplinarity in different ways. Jim, yours is sort of 3 levels deep, and right, because it's what Dick thought about what Kennedy thought. And so in some sense, the question is the question that was posed to me over the Zoom. Like, so what do you think the subjects that you're talking about would think about interdisciplinarity now? So Ken, you don't have to quite say that because Marty's there, and so I think we can assume that he thinks we're kind of more or less doing an okay job. So it would be interesting in the sort of spirit of looking forward by looking back to get your sort of reflections on what interdisciplinarity looked like in the past to the folks that you've talked about, and what lessons we might take from that in the future. And then in parallel to Kent and Brenda, one thing that I think both Marty and Alan had in common, and that I think actually both you two have in common, is the way in which everybody uses their skills, their lessons as law professors to kind of engage with the broader world, right? So it's at the level of policy, the participation in the parliamentary debates and stuff like that. And I wonder if you have thoughts about how we might think about doing that as we move into the future, to the extent to which law professors have some obligation distinctively to be, sharing our expertise with the goal of shaping public policy.
Okay. So if I got your question right, you're right. You've actually read a draft of my paper, I understand. So, when I was reviewing it today, I realized there are parts of this that are a bit of a mess, because I keep saying, and here I am talking about Kennedy, and here I am talking about Risk, talking about Kennedy. So I can see how that's kind of confusing. But I think that's what made Kennedy so fascinating to Dick, because he did believe in the interdisciplinary law school, and so we had a real opportunity both to unearth a part of this part of Canadian legal education which hadn't been written about, and yet also there was a part of his mind, I think, which was also judging it, right? How well did it work? He could just, the historian's job is to describe and to unearth a different way of thinking from a different period than the one that we live in. So Dick was doing that, but at the same time he was doing it while he was in a law school which was considering itself to be increasingly interdisciplinary. So he was trying to kind of think about how that related to what Kennedy thought about it, and etc. And I say this in the paper, although Dick didn't say it in his article on Kennedy, but I think Dick in the end was kind of thought Kennedy's law school was, good try, but actually you can't keep them so separate, right? That the idea of actually trying to teach doctrine, but embedding within that doctrine the insights that you can bring from some other kind of discipline, was, I think, quite strong. And both Dick and I actually had the same attitude to teaching, right? Which was, we have this job of teaching what the law is and what thinking like a lawyer is like, but we also have the job of saying to our students, the law comes from somewhere. It doesn't come out of the ether. With great respect to Ernie, it doesn't come out of Kant or anybody else. I'm sure you didn't think that, but nonetheless, it comes out of material circumstances and particular societies at particular times making choices, and the law is relatively autonomous. It's never autonomous entirely, but it's also never derivative, etc. So we both use history in that way as an illustrative thing. And I don't know who said it, but you're quite right to say that when Dick became interested in the rise of the administrative state as a legal historian, he turned to teaching administrative law, right? A bit later on, when he became interested in the history of Canadian constitutional thought, he turned to teaching constitutional law, because for him, it was very much part of his. So he's one of the four authors of the classic administrative law text. One was John Evans and Hudson Janish. And he was one of the earliest people who contributed to the Canadian constitutional textbook, which I believe is still used, although there's a sort of rotating and ever-changing string of authors, but his name's probably not on there anymore, but it certainly was initially. Yeah.
And also responsible for bringing a lot of history into that first version of the constitutional law text. Yeah, no, I agree. Marty kind of addresses this in the 1975 Courts and Trial book, where he says it's about multidisciplinary. We're not yet at interdisciplinary. So I'll leave it up to Marty to say whether we're actually at. But one of the things that I guess caught me is that. And Michael talked about this a little bit when he said when we started to do law and economics, we were bringing in people from other parts of the university. There is a real kind of humility to Marty's approaches. You see it change maybe a little bit during the Sanctions and Reward project, which I think went over 3 books, where there's more law professors. But it really starts out as we have something to learn at the law school, and we're going to bring in someone from outside. And one of the arguments that I make in my paper is I think we need to re-engage with the rest of the university, because we cannot, in any law faculty, no matter how well resourced, we cannot reproduce the riches of the university. I am concerned that we are privileging economics and philosophy and not looking at other things that not only are intellectually interesting, but that our students will actually need. So like when I teach criminal law, I tell my students, a lot of people go to law school because they can't get into medical school. Well, if you're going to do criminal law, you better understand some things about forensic science, because if you don't understand forensic science, you may be participating in a miscarriage of justice, which was why Marty included the Truscott case. And of course, when I came along, I said, oh, Truscott's old hat, and we put in the Donald Marshall Jr. case. And Marty was, incredibly generous to me. And then it was only after I worked on the Gouge Commission about miscarriages of justice caused by bad forensic medicine that I, really realized that Marty was right after all, right? So, I'd like to see us have courses, or, even, dare I say, bridge weeks, where students, get an exposure to science, get an exposure to statistics. All of these things are actually relevant to the profession. That I think is the advantage of Marty's perhaps softer and less well-known approach to multidisciplinary, as opposed to Harry Arthur's, who has really, I think, won in a sense in terms of moving us much more to the humanities and social sciences, which are all obviously important and included in Marty's work, but he would also reach out to the business school, the engineering school, the medical school, and other points. In terms of our, Marty often wrote for a broader audience, and, I'm kind of jealous when, parts of Detention Before Trial and other books were excerpted in the Globe and Mail. And I think that that's, part of it. Marty was also part of, what I still think is a pretty extraordinary history of the law school, when Ron Daniels arranged for us to write a book while the Anti-Terrorism Act was being debated, and Marty was part of that chapter, part of that endeavor, and he was also being consulted by the federal government in a way that a lot of us wouldn't, about what the Anti-Terrorism Act is. So one of the other things that I argue in the paper, and again, this is kind of using Arthur's as a foil, is the Arthur's report disparages, he contrasts research sublime with research punctuel. right? And Marty did a lot of research punctual, which is, you know, the McDonald Commission asked him and John Edwards to do background studies about how to rethink the role of policing and intelligence and national security, and the Somalia Commission asked him to rethink that, and the Canadian Judicial Council says, you know, how do we guide judicial behavior? So I would argue that Marty's career demonstrates that there's an academic payoff to research punctuel, even though the Arthur's report seems to suggest that it's somehow inferior and that law professors do way too much of it.
I will think about that, but I'm going to cede my time to the senator from Toronto.
Okay, very good. Marty.
First of all, I'm blushing. I would like to thank everyone for their kind comments. At my age, it's quite nice to hear them. But the ideas weren't mine. They often came from other people. You mentioned Hearst and then the importance. And I thought, wouldn't that be an interesting article? The 10 Americans who have influenced the development of this law school. We hear the importance of Paul Weiler. In my own case, the person who was most influential is somebody that perhaps isn't remembered. Caleb Foote from the University of Pennsylvania. In two ways. Ed mentioned the empirical study. I was teaching a course in criminology at Osgood, and I was interested in bail, and the students were interested in it. And Caleb Foote had published an article on bail in New York City, and bail, another article on bail in Philadelphia. And we brought him up to talk to the faculty, and that was the start of it. I became friendly with Caleb Foote, and when I was became dean, he told me about this development at Berkeley that I should think about. And that was to have every first-year student have a course with about 10 or 15 students. And that led to the small group program here, which nobody has mentioned here, but it's in fact one of the reasons why the school functions so well with big classes, but congregating and having friendships and communication with a professor in a small group. A third thing that I can mention here, is Kent's right. The approach that we took was a multidisciplinary approach, and that courts and trials doesn't say interdisciplinary, it says multidisciplinary. Another thing I could mention, we had an interesting discussion earlier on what would Bora and Caesar and John Willis think of the law school if they came here now. I'll end with this. And there's no question Willis would say it's a great law school. Bora would say it's a very good law school. And Caesar Wright would wonder whether we'd gone too far. So I'll leave it at that.
Okay. I think that kind of is the wrap-up word for this panel. So thank you very much. Thank all three of you for these wonderful perspectives. And if you think that we've reached great heights, you're right, we just did, and in the first panel as well. But we have yet another treat ahead with colleagues speaking to Stephen Wadhams, Ernie Weinrib, and Michael Trebilko. So 15-minute break, and then upwards and onwards. See you soon.
Okay. We're gonna everybody's settling into their seats. We're gonna move into our next panel. I think I've heard people say in the past, so I'll endorse this, but I'm somewhat repeating what other people have said. I think it's fair to say that that sort of between 1968 and 1972 was a moment at which a fledgling law school was, by the hiring of the three people who'll be the subjects of our next panel, it was like pouring gasoline on a fire. Things started to get extremely exciting, and the level of work being produced shot into the stratosphere. So I'm really excited about this panel, also because this is actually, interestingly enough, the first panel on which the subjects that are being discussed were people who were at the faculty when I was here as a student. I mentioned earlier that I had both Ernie and Michael in my first year, and then I took a class with Stephen in my second year. So I'm really excited for this. So we've got Peter Benson, Professor Peter Benson is going to talk about Stephen Wadhams, Professor Arthur Ripstein is going to talk about Ernie Weinrib, and Professor former Dean Ed Jacobucci is going to talk about Michael Trabilko. So I will turn it over to them. Thanks.
Okay, it's working? Okay, good. I'm really honored to be able to speak on this panel because it honors three of my teachers, the late Stephen Wadhams, Ernie Weinrib, and Michael Trabilko. I can't say how much I've learned from each of them. It's beyond words, and I will keep learning from them, and I cherish every moment I've had with each of them. And I just want to say a few words about Stephen. Like many of you, I was his student in first year, and maybe it's probably the case that there are more of us who can say this than of any other teacher, because in the history of the law school, because probably he had more students than any other teacher in the law school. I want to say a little bit about what he was like as a teacher, and then as a scholar, and then very briefly where he stands in my mind. As a person and as a teacher, he was so understated. He was so kind, clear, insightful, comprehensive, and erudite beyond words. And one couldn't go away from his classes without having kindled a true love of the subject in contract law. And I see this, I saw this with myself. I see this continuing with students who had him. Up to the very last moment he taught. He taught right to the end. And he loved teaching because he viewed all of us as students of the law. And in his very last class, and I've talked to students who were in his last class, he was very weak. He would speak from the microphone. Sometimes it failed. Students would crowd around him, trying to sit in the first two rows. They've kept his notes. They refer to his notes even now. On the last day, he told them that it was his great honor and privilege to have taught them. And again, they rushed to the front, asking him to autograph, to sign his book, his case book. And they came away thinking that this is what law school can be and should be. And I know that I've talked to students in my upper year seminar that as the years go by, the memory of what they learned with him and his significance as a person and the way he conducted himself has become even more important in their lives. Stephen wrote a very interesting piece about the late Professor Coote in 2022, just before he passed away, before Stephen did in 2023. And it's very interesting. And he says near the end, Brian Coote could certainly have written an excellent treatise on contract law, but it is not entirely a matter of regret that he did not do so, because freed from the treatise writer's attempt, never completely successful, to be comprehensive, he was able instead to write more deeply and more cogently on particular issues that commanded his and hence his readers' interest. Well, the thing about Stephen was he was able to do all of that. Bursting on the scene in 1976 with his article, Unconscionability in Contracts, which the great English historian David Ibsen says just in a footnote, seminal is Wadham's Unconscionability in Contracts. He then went on to write, including his casebook, 10 books, all of them serious, all of them comprehensive, all of them illuminating and challenging. I can't speak of his, really of his history books, but in terms of contract law, there's what's really striking about his writing is not only its elegance, he was an amazingly elegant writer, not only its erudition, and I think in terms of pure erudition, he was unequaled in the common law world of his generation in terms of the common law, but also in terms of a theme that he was developing, which he continued to work on from that very first article in Unconscionability in Contracts right up to the end, still searching for what he thought was the best answer. And he started off, and it's just wonderful when he started off Unconscionability in Contracts. He said, several generations of common lawyers have been educated in the belief that the common law of contract admits no relief from contractual obligations on grounds of unfairness or inequality of exchange. This rule might seem hard, it is said, in an individual case, but is justified by the need for certainty and commercial stability for, quote, the chancery mends no man's bargain. My view is that the law of contract, examined for what the judges do, as well as for what they say, shows that relief from contractual obligations is in fact widely and frequently given on grounds of unfairness, and that general recognition of this ground of relief is an essential step in the development of the law. And so he worked to try to show that no civilized system of law can accept the implications of absolute sanctity of contractual obligations without integrating properly, as not marginally, not as an exception, but centrally, the requirement of fairness or justice between persons. And so his work, which covered so many different things, but I'm just focusing on this one theme. His work in the following decades was to deepen and expand his claim, both as a truly disinterested study, as he would call it, of the principles of fairness in conjunction with the principles of formation and other aspects of contract law. The thing about Stephen's work, and it's very rare, and I would say, at least I have found it, you could trust his work. He didn't write, and I'm coming back to this, a philosophy of contract law. But his attitude, his approach was philosophical in the sense that he was more than anything else concerned to figure out the truth of the matter. And he could be counted on to know the laws, to figure out what was the role of fairness in contract law. But there was a practical aspect to it. It wasn't just trying to figure it out and give a coherent approach, but it was also an attempt to move the law in a certain direction. I can say that, and it may be true of other scholars, but it was definitely true of him, and it's an extremely rare thing, that in him, the common law was working itself pure by drawing its principles from the fountains of justice, to quote Lord Mansfield. And he, more than any other writer in contract law, and among the greatest writers in private law, moved private law and contract law, in terms of its content, to a full recognition of the requirement of justice between parties as an essential part of contract doctrine and contract law. In his last major book, Sanctity of Contracts in a Secular Age, he said, one of the most important questions in contract law is the extent to which enforcement will be withheld of contracts that are very burdensome or hardly unreasonable. The same theme, coming back to it over and over again. English law and the law of cognate jurisdictions is in a state of disarray on this fundamental question. Relief has, by a wide variety of techniques, been given against very burdensome contracts when they fall into particular categories. But when they do not, relief has been denied, with the results that are in some cases avowedly grotesque. Much has been written on separate aspects of the matter, but these writings, though useful, are not sufficient. a comprehensive review of the whole law on this question and of the interrelation of its various parts is both from a theoretical and from a practical perspective a pressing necessity. So again, he came back to this theme. I think it's a sign of a great thinker and a deep scholar, and I think of what Rawls was doing with his own work, to come back to something and keep thinking it through that is fundamental. And that's what he did. And as a practical matter, he kept trying to formulate, in my view, how to reach a consensus on this question of the centrality of fairness in contract law. And so in the original piece, he said we need a general principle of unconscionability. Along the way, he asked whether good faith could be such a principle, or abuse of rights, or anything like that. Then he came back to what he called, saying it's not unconscionability, it's not good faith, it's not these other doctrines, but he called it a general residual power to relieve from unreasonable contracts. Now, this, you might think, is very undefined or ill-defined and open-ended, and it's not very philosophical. But I think he was very aware of what he was doing, extremely aware. And what he was trying to do was to persuade and educate students, courts, scholars, that there was a possibility of coming to some kind of shared understanding about the fundamental nature of the contractual relation, the fundamental nature of enforceability of contracts, and the role of fairness. He said, contract law in the sanctity of contracts has often been visualized as demanding absolute sanctity of contract subject to such limits as equity supplies. As we have seen, this perspective has given rise to many difficulties, some of which could no doubt be alleviated by adopting an expansive view of equity. But it is also possible to envisage the concept of enforceability as its self-containing inherent limits. The two lines of thought are not inconsistent and can be pursued simultaneously. This idea of figuring out, of thinking through the concept of enforceability and the inherent role of doctrines of fairness is something that he put forward for future thinking and future study. Now, in terms of his relation to theory, and it connects up what I was saying, and the fact that he used terms like justice between parties, he talked about fairness, et cetera, without defining them. It's clear he could have defined them. It was clear he was aware of all the important work that was being done, for example, by Ernie, and corrective justice and everything. He didn't do it, I think, explicitly, because that was not his aim. His aim was to work with ideas that would be intuitive in judgments and understandable generally, and could include a family of conceptions of interpersonal justice, including certain accounts of corrective justice, including other accounts of interpersonal justice. He felt that this was something that was part of our sense of justice, part of our educated sense of justice, and could be understood more generally. And so he wanted to put it in those terms to try to achieve where he said there is not even now a consensus, how to push to that consensus. And I think that, in my own view, I view his work as truly monumental in building an edifice of understanding of the law, which could then be theorized, maybe by taking a little step, but it will last. And it is of permanent significance, it seems to me. And this is something that is very rare for a scholar to be able to achieve. And so the fact that he did not express or invest or think through in terms of his writing the philosophical significance of what he was doing doesn't mean he was not aware of it. And I really think there's something deeper going on in what he's doing than what usually counts for theory or philosophy of law. There are exceptions, and we have an exception. But generally speaking, in my view, the theory of law and the philosophy of law begins with certain presuppositions, which are taken as given, and then you apply them to the law, and you illustrate them in relation to the law, but it's not working with the law. It's not building it. It's not understanding the animating ideas in the law. It's not allowing the law to work itself pure in the way that is possible. And so it's actually kind of superfluous in my view. What's not superfluous is the work that he did and the possibility of giving it to future generations to think further about. He was a great teacher. He was a great scholar. He was a great human being, kind, gentle, sociable, always showing respect. In my view, he counts among the greats in contract law. I put him up with Williston and Corbin. There's no one in the common law world since then that equaled his ability. We were so fortunate to have him here, and he will never be replaced, and he will always be missed, and he will always be a source of learning and study, even closer when he's gone than even when he was present.
Thank you, Peter. That was lovely. Arthur, over to you.
So I want to begin by thanking the organizers for giving me the great honor of speaking about the work of my dear friend and colleague, Ernie Weinreb. I want to thank Ernie for his superb work. I want to thank Jim Phillips for giving me the perfect foil for the remarks that I'm about to make. And I want to also, as is customary on these panels, begin by thanking Marty Friedland for creating the culture of mentorship of junior faculty. Each of Ernie, Stephen, and Michael were junior faculty when Marty started as dean. Each of them went in their own direction, which was a different direction than the law school had been going in up till then. Marty encouraged them, Marty supported them, Marty built their careers, and that is why we have the law school that we do today. So, thank you, Marty. I want to now talk about Ernie. Before talking about Ernie, I just want to say a sentence about favorite experiences with each of Stephen and Michael. My favorite experience with Stephen was when I was working on my book on private wrongs. I was working on the chapter on defamation. There's a large literature about whether saying that someone has a loathsome, what is meant by saying that someone has a loathsome disease. And so I wanted to read all of the old cases, and Stephen and I spent a full day translating 2 pages of law French. It was amazing. I got home at 7 o'clock. There was an email from Stephen. I've thought of a different way to translate this word. Law French is all in abbreviations, and so you need to expand. So that was wonderful. My experiences were with Michael and I, in a certain way, come from different intellectual worlds in the ways in which we approach the law, in the ways in which we approach questions of policy. But talking to Michael, he would always make me stop and think, well, if that was right, then what else would happen? His way of seeing things in a way holistically, looking 2 steps away, and as exemplified by his wonderfully titled book with the subject we should all be dealing with losers. What happens when for the people for whom it doesn't work? So I'm grateful to all of you for being my colleagues, but to Michael and to Stephen for such deep and meaningful intellectual exchanges. Now, about Ernie. So let me start just by saying that I go and give a lot of talks at other institutions, and people would always ask, so what's it like having Ernie Weinreb as your colleague? And I'd say this and I'd say that, and finally, I read an interview with Ingmar Bergman. He made a movie of the Magic Flute, Mozart's Magic Flute. They said, and how was it? And he said, it was the greatest time of my life. You simply cannot imagine what it is like to have Mozart in the studio every day. Having Ernie next door, you just can't imagine what it is like. As the intellectual thrill, I would show up in his office with a half-baked idea, and he would take it further and take it deeper, and we would talk for hours. And sometimes it would turn out it went nowhere, but it was worth the journey, and sometimes it would take you very far. So I didn't get the memo about wearing a turtleneck, but I did get the memo about choosing one piece of Ernie's work to talk about. And so the piece that I decided to talk about is the idea of private law. And obviously, I don't have time to even begin to do it justice. But I want to begin by just talking about how 30 years after its publication, I reread it for the umpteenth time. And I was struck by certain features of it. It has the mark of many works of great scholarship in that you read the various people with whose work Ernie engages as a way of orienting his reader for where he is going. And some of them you think, oh yeah, forgot about that person. They were useful landmarks, but the work survives the fact that the landmarks are no longer there. But the main feature of great scholarship that it exemplifies is, of course, that it is the resolute exploration of a single idea and the working out of that single idea in all of its ramifications. And the single idea is an idea that can be stated in a way that makes it seem completely unremarkable. The idea that in private law, you have to think about the relation between the plaintiff and the defendant. Well, who else? But the plaintiff and the defendant show up as a matched set throughout the idea of private law, as the plaintiff and the defendant, as the person who commits a wrong and the person who is wronged, as the person who must pay over money and the person who receives money, as the person to whom a duty is owed, and as the bearer of the right that is correlative to that duty. And what Ernie does is show the way in which this set of ideas, this matched set of the plaintiff and the defendant, provide a distinctive form of thought. So here's where I thank Jim. Jim said, the law was not invented by Kant. And of course, Kant would be the first person to say that in response to an early review of one of his books. He said, far be it from me to invent a new moral principle. If anything, Kant was invented by the law. All of his philosophical ideas came from reflecting on Roman law in the Holy Roman Empire and what was true about it, what was wrong about it, what its presuppositions were, what its limitations were. And from that, he came to see that it was a model for what reason could achieve and what reason could not achieve. Ernie's aim is not to find the origins of law in Kant. Of course, law is a historical project. Of course, law is a historical product. And of course, law is, when successful, a historical achievement. The point of starting with the law as it presents itself, as the law claims to be, or as Ernie sometimes puts it, as the law understands itself, is that the law presents itself as engaged in a rational activity. The plaintiff comes before the court, complains that the defendant in particular has wronged that very plaintiff, and demands a remedy from that plaintiff, defendant. How are we to understand that as a rational process? And the answer, Ernie says, is to focus on that relationship, because if we focus on that relationship, then we can see that what the plaintiff suffered and what the defendant did are the same thing. They're not different things, they're the same thing. The remedy paid by the defendant, the remedy received by the plaintiff are the same thing. If we think about it in that way, we can see a way in which it is a coherent enterprise. Now, the word coherence gets a lot of play in philosophy and in other disciplines, and it typically means something like, let's see if we can explain as much as possible with as few principles as possible. But that's not what Ernie means by coherence. What Ernie means by coherence is that we can understand the reason for something in terms of the relation between the things that are being justified. We can draw a distinction, as Ernie does in other places, between two different ways of thinking about remedies in the law. One of them sees the wrong as the occasion for doing something. I've wronged you. Oh, look, this is an opportunity for us to do distributive justice. Or this is an opportunity for us to deter other people. Or this is an opportunity to see to it that welfare is maximized, or this is a way to, this is an occasion on which we can provide suitable incentives so less of this will happen in the future. It's not that you can't think that way. It's that that's not the only way in which you can think. And Ernie's insight is that in order to understand private law, the law of tort, the law of contract, and the law of unjust enrichment, we must begin by thinking in terms of the reasons. But the reasons are always correlative. If we see them as correlative, we see the plaintiff and defendant as related, and we see the entire rationale, both telling the defendant, this is why you must pay over this sum of money to the person with whom you breached a contract or whom you tortiously wronged, or to the plaintiff, this is why you do not receive a remedy. This is why you have failed to either state a cause of action or failed to establish all of the elements of the wrong. It's by looking at both at the same time, we can see that there is a distinctive form of justice. Following Aristotle, Ernie characterizes this as corrective justice and distinguishes it from distributive justice. Corrective justice has its distinctive form of coherence in that it relates the parties before the court and doesn't look to anything else. Distributive justice gets less attention in Ernie's writing, though in Reciprocal Freedom, he devotes a full page to the coherence of distributive justice. But I want to just pick up on that page and on that one sentence in the idea of private law to note that in distributive justice, you have a very different picture of coherence. That picture of coherence says that someone is distributing something among a group of people. The distribution is coherent if everyone gets what they get because A, they are a member of the relevant group of people among whom the thing is being distributed, and B, it is distributed on the relevant ground. We have a marking scheme. We give out H's, HH's, and P's, and how do you give them out? You give them out on the basis of the assessed academic strength of the written work. And to whom do you give them out? Well, it turns out you give them out to all and only the students in your class and nobody else. But if, of course, you start saying, oh, I'm going to give out grades differently, I'm going to try and create incentives for people to do something else, or you give out grades to people who are not in your class, or you withhold grades on the basis of the comparative merits of someone who is not in your class with someone in your class, you're not doing your job, you're not doing it coherently. So too, when you are in any other distributive context, someone in particular is charged with giving something out on some particular grounds. Ernie uses this distinction between corrective justice and distributive justice in order to demarcate the difference between private law and public law. Private law is concerned with relations between private persons. Public law is concerned with relations between persons and the state, but that means public law operates through distributive justice by assigning particular officials particular mandates in distributive justice, assigning officials the power to determine who gets taxed, who receives various benefits, who participates in various forms of mandatory social cooperation, and so on. If we see it that way, then we can avoid the distributive justice in action. Chris showing me that I am running out of time. We can see that a certain picture that often shows up both in the legal academy and in the broader political culture according to which there must either be the subordination of all of private law to public law, an idea defended by some, though not all, members of the economic analysis of law, or the alternative view according to which there should be the subordination of private law, of public law to private law, that people should only get what they pay for, that no one should need to contribute to anything unless it is a purchase in which they are receiving the equivalent of what they paid, that we don't need either of those pictures. We can instead have the picture on which there are two distinct forms of justice. We can have these two forms of justice, and we can understand that sometimes there will be a question for us as a society of which form of justice will prevail. Sometimes there will be a question about whether doing justice between the parties is the right thing to do, or whether instead something should be treated as a problem of public health. Workplace injuries are a nice example of that. Many readers of Ernie's work have come away with the impression, oh, you should be opposed to all forms of social insurance. But it's nothing like that. The point of understanding private law is to understand how there can be a rational justification for looking to what has transpired between two legal persons in order to order one or the other of them to do something. That is at the heart of private law. That lets us understand how it is it can be a rational enterprise. And for that, we must thank Ernie. Thank you.
Thanks, Arthur. Ed, over to you.
Great. In tribute to Michael's love of technology, I have some slides. Well, it's thank you to the organizers. It's humbling to be on this panel, given the subjects of this panel, given the speakers at this panel to my right, and of course, given the subject of this particular talk about Michael. I'm well aware that when it comes to Michael Trabilko, there are dozens of people who could claim to be his mentee and to have owed him a significant part of their professional successes and happiness. I certainly count myself among that group, and certainly also count myself very lucky to have Michael as one of my close friends. So it's daunting and humbling to be speaking to you today. I want to talk about sort of Michael Trabilko and his attitude towards different kinds of trade-offs. But where do you begin? We're talking about Michael. He does it all. So he's one of the best teachers this law school's had, one of the best scholars, and a tremendous community contributor. The number of deans who counted him as a key consigliere is probably everyone since he started. But he's just been an all-rounder. So one way to think about it is by metaphor, and you can think of Michael as Kane Williamson, Sir Richard Hadley, Tom Blundell, and Daniel Vittori, all in one. And I'm glad Michael was giggling. I had a feeling that you might not know who these people are, but they are New Zealand's finest batsman, New Zealand's finest fast bowler, New Zealand's finest wicketkeeper, and New Zealand's finest spin bowler, which was what Michael was, all in one person. So imagine that, and that's what Michael is as an academic. But even just turning to his scholarship, just one aspect of his tremendously successful academic contributions, focusing on one or two tasks is one or two works is daunting in a career that has covered consumer protection and deeply, not just a sort of one or two dips of toes in the water, but deep contributions to consumer protection, competition law, contract law, law and development with Mariana, immigration law, regulated industries, trade, and other things. It's as I say, daunting to think of one or two things, and so I'm not going to do that. Instead, I want to talk about a few different kinds of themes that permeate his work. First, I want to talk about kind of trade-offs within law and economics. And Peter and I neither coordinated on the turtlenecks nor on the emphasis on fairness in contract, but there'll be some resonance in my discussion of this first paper, The Post-Benthamite Economics, which talks about fairness in contract in a House of Lords decision. Secondly, I want to talk about trade-offs across different normative perspectives. So there's the trade-offs within law and economics. What about law and economics versus other kinds of perspectives? And that's where I think limits of freedom of contract is an important work. And then talk about his work on institutions, which is an incredibly important part of his scholarly work, and in some ways kind of ties some of these themes together, as I'll try to say in my fourth observation. I'll talk a little bit about competition law institutions there. Okay, so post-Benthamite economics, this first paper, a 1976 paper. It helped establish Michael as one of the founders of the law and economics school anywhere. And it was itself important for its contribution to the economic understanding of contract. And if you could sum up Michael's approach to this case, but that he discusses, but his work generally, it's to reject superficial answers to complex questions. I recall as his student admonishing his students when asking a difficult question, always with a giggle, that characteristic Trabilko giggle, saying, I want an answer, I don't want a visceral grunt. And what he shows, I think, in his discussion of this case, Macaulay, is that the House of Lords provided, I think, and he thought, a visceral grunt, though he didn't put it that way. So here, just quickly, some of you will know this case. Unknown songwriter signs a contract, 5-year term. It's renewable at the publisher's option if there's a certain amount of royalties generated. Songwriter wants out of the contract, saying it was unfair. The House of Lords agreed, said there was inequality of bargaining power that was manifest in this very unfair term, that only the publisher could terminate the contract, but not the songwriter. So there was kind of this one-sided option that was problematic at the House of Lords, and I'm distilling a much more complex discussion into bullet points. The House of Lords was also concerned that it was a standard form contract, that this seemed that the corporation offered this poor songwriter. Okay. Michael, I think it's fair to say, dismantles the House of Lords reasoning and makes several observations that I think were relevant to the case, but actually are relevant today in various important debates that we still have. One is, if inequality of bargaining power claims derives from some claim about market power, that is some absence of competition, then why don't you have a look at the facts? Take those facts seriously about the competitive situation in which the publisher found itself. House of Lords doesn't talk about this source of unequal bargaining power, instead just kind of comes to this conclusion. Well, Michael actually did some empirical work. Again, kudos to Marty, because this wasn't done enough, and kudos to Michael for having done this. Turns out there were over 250 music publishers in the UK at the time, and the publisher in this case was literally a husband and wife team. It was a mom and pop operation. Didn't seem like one that would have a lot of market power. That source of unfairness didn't seem to be plausible. And I worry in lots of modern public debates that there's also kind of fact-free, kind of careless assertions of market power, recent discussions about grocery prices in a time of general inflation, yet somehow the grocery stores must be exploiting their market power. It strikes me as kind of not that careful empirical analysis. Okay. Standard form contracts are not intrinsically suspicious. And Michael, it's a really wonderful discussion of some of the risks too. He's not naive about the risks of standard form contracts, but also takes a very thorough understanding of some of their benefits, including the savings on transaction costs, which that can result from having a standard form that you don't have to kind of haggle over every term every time. And that's why he suggests that they're ubiquitous, even in competitive markets. And if there were problematic terms, you would expect competitors to be able to point out the problems with those standard form contracts. It's unlikely in this case in particular that the songwriter didn't know what he was signing and was somehow duped into signing this. The fact that it was a standard form contract doesn't really seem to be neither here nor there. And that in this case, as Michael, I think, rightly points out, again, this is a discussion. I think Uber and Heller did not cite this paper. The recent Supreme Court of Canada case involving a standard form might have been useful had they. Perhaps the most important piece of his criticism of this case is to take economic trade-offs seriously. So basically, the House of Lords reaches a conclusion that this contract was economically unfair to the songwriter because the songwriter didn't have this option to terminate. Michael provides an incredibly persuasive understanding of why there was this one-sided option to terminate. It's because these contracts were really risky. So you sign this unknown songwriter. Most of these contracts failed. Most of these the songs didn't go anywhere. The efforts to promote the songs were unsuccessful. And so Michael's point was, if you have a portfolio of songwriters that you signed, if the ones that become successful can just walk away from their contract, then you're going to end up only with the contracts that are losing. And so if that's the case, then of course, at the time of your signing of the contract, it's not going to be attractive to the publisher to enter into that contract. They need to have some assurance that they'll have some opportunity to make a return ex post if most of the time they're going to be losing money. And that, by the way, is not just good for the publisher, that's good for the songwriter. The songwriter wants to be able to enter into this contract. And so the one-sided termination right could be understood as completely fair as between the parties, to use other people's terms, but efficient would be another way to put it, as economists might put it. Today, again, I think highly relevant. You hear about intellectual property owners gouging, by charging extremely high prices. Maybe that's true in some cases if we knew what gouging meant, but it's also important, I think, to understand the risk that went into the investment that led to the intellectual property, and the ex ante, ex post distinction remains an important one that I think too often gets glossed over. So incredibly important, I think, paper in lots of different ways, including ways that continue to resonate. Let me shift gears, and I'm going to try to cover a lot of Grant. Then there's this book, The Limits of Freedom of Contract, which I would describe as a kind of ecumenical approach to law and economics. I wonder if it's possible to get that window closed so people can see this quote. There, it's gone. And I'm going to commit, at least risk committing academic malpractice by citing a jacket blurb, because I actually think this is a wonderful encapsulation of this book and Michael, and an important dimension of his work, and describes Trabilko as unique among the inheritance of economic paradigm for the way he does justice to the complexity of views about the appropriate scope of the market domain. And I'll skip to the end. Above all, he takes seriously the overarching humanitarian agenda of ending deprivation and oppression. So Michael is actually quite open to the idea that some things are unfair, but would just require careful thinking in reaching those conclusions. And so one way to think about it is that he rejects lazy economics in post-Benthamite economics in the House of Lords, but rejects lazy economic chauvinism in limits. Economics has something to say, but so do a range of perspectives. One of the examples he discusses is surrogacy contracts. And in discussing these, he considers economics, autonomy, feminism, commodification, religion, in thinking about whether these ought to be permissible. He critically discusses the arguments and doesn't accept all of them equally, but he doesn't a priori say that one perspective has more value than the other. Right? He takes them seriously, and he reaches a kind of compromise that maybe in the interest of time, I'll just briefly say. He says, yeah, I think they should be enforceable, but regulated. There should be a kind of mandatory period after birth where the surrogate mother can decide, that is, the birth mother can decide whether she wants to relinquish parental rights or not. And he views that as a kind of compromise. Protects against exploitation. It may undermine some contracts, but it protects against exploitation and is a kind of optimal compromise. It's a contestable conclusion, but it's informed, it's wise, it takes into account, I think, a variety of potentially important perspectives on something like this. Institutions. So he's made these contributions, these substantive contributions to law economics, is a unique contributor and remains really the foremost kind of ecumenical law and economics thinker there is, but is also a major contributor to the study of institutions. There's a variety of works, choice of governing instruments, his work with Mariana on law and development, dealing with losers itself has institutional dimensions, even his last book is on public inquiries. He and I wrote something on institutions for pandemics at the last of these law in a changing world conferences. I want to talk briefly just about competition law institutions, not because it's its most important institutional work, but because I understand it. Because that's one of the things, he and I have written some things together, and I'll talk about his role versus mine. mergers in critical infrastructure industries. So we've gone from these big philosophical questions to kind of pretty esoteric question. So who gets to decide about whether a merger should be approved in major infrastructure industries like finance or transport? Well, the Competition Act says that the Competition Tribunal, which normally oversees these things, does not in these particular industries. Rather, the Minister of Finance and the Minister of Transport do. I've read that as 20. In telecom, also it ends up because you needed the tribunal approval, but then you still needed ministerial approval to transfer spectrum licenses. So in work with Michael, we supported the idea of political oversight of mergers in these industries. And I say we advisedly because I remember resisting this idea, thinking if you have ministerial oversight, there's going to be considerable kind of rent seeking and the usual kinds of potential corruptions of the political process. But he insisted, saying these issues are too big to be decided by just the tribunal. They ought to have this political oversight. And I came around, and I'm even more convinced that that was right today. Infrastructure mergers raise garden variety competition concerns. The tribunal can do those things. But it also raises other kinds of concerns, sort of just under a bucket of social concerns. National security, regional development, prudential regulation in the case of finance, employment, consumer access to critical services, et cetera. Competition authorities are well placed to consider competition issues. They're not well placed to consider the social issues. They neither have expertise in thinking about these problems, nor are they politically accountable. So I think there is a good argument for having a two-stage process with a tribunal review and then having a ministerial or a cabinet review. It's not perfect. There is a risk about politics, but exploits institutional comparative advantage. Okay, technocratic questions go to technocratic institutions, and political questions to political institutions. In my last, I think 10 minutes is all I have left, I just want to draw connections between these things. No, I'll finish. I'm going to focus just on this. When we're thinking about these sort of normatively polycentric questions, Michael provides, and I think it's important when you're thinking about his body of work, to think of him as providing two kinds of answers. So one is found in the limits of freedom of contract, where he avoids simple-minded tautologies that others have provided, that welfare must be the best because only maximizing welfare maximizes welfare, which honestly is close to that whatever 250-page book can be distilled to that point. Instead, he offers kind of careful analysis and I think quite wise recommendations in limits. But all of those kinds of, I think, wise recommendations are inevitably contestable. But he also offers a different response, which is to think about this institutionally, is to think about when you have these polycentric kinds of problems, you don't want a technocratic institution dealing with them, right? Conversely, if you have a technocratic question, assign it to a technocratic institution. And so I think that should also be seen as connected to his work in limits. His institutional work and his work in limits are connected. And it provides a different kind of institutional way of thinking about how we resolve these really difficult questions that he's not scared to take on. Okay, thank you.
Okay, thanks to our panel. So I assume this will be easy. So many people in this room have learned so much from one or more of Stephen and Ernie and Michael. So I'll open the floor. I'll offer Michael and Ernie first dibs, last dibs, up to you. We're happy to hear from anybody. Mayo.
Thank you so much. I think you all explored so well and you were only able to touch on the incredible scholarly contributions, but I also noticed, and I feel it myself, how emotional everyone sounded as we're talking about these folks, and just wanted to suggest two reasons for that and to get your thoughts on it. One, as many of you said, and you know, Marty, it goes back to you, we are their children. Right? This faculty is what it is, and so when we were talking earlier, what are we? We are what we are because of them. I'll get emotional again, but that's okay. And part of it is the scholarship and the incredible commitment to their scholarship, which and the depth of it. But also, Ed, I was struck with the quote, the Peggy Radin quote from the Dust Jacket for Michael's wonderful book. And you emphasized the last line, but I was struck by the line ahead of it, which referred to his profound engagement with points of view that were different than his own, that were communitarian and philosophical, and there we go, feminists and communitarians. And so just emphasizing that Michael takes seriously those arguments, and I think that could be said of every person that we're talking about here, and just wanted to emphasize that the whole is even greater than the sum of the parts in many ways, great as those parts are, and just wanted any reflections. I'm sure all of us in this room have memories we could share about how that interaction between these amazing thinkers really created something very special that was beyond even the wonderful individual contributions that they made. Thank you.
I'd be happy to jump in. So I think at one point we were actually trying to figure out, this is just one example of Michael's kind of role as a mentor, who had supervised doctoral students. I think it was when you were dean, right? Yeah. And I think it was close to Michael had supervised more students than the rest of the faculty combined. And that's not to say that my colleagues were slackers in supervising others. It was just his remarkable energy and enthusiasm for mentorship. And let me say, one of the things that made him such a fabulous mentor, and also for me, just personally, made me think there is really something special about the academic enterprise, was I was his RA, one of his army of RAs after my first year in law school. And what was remarkable to me is in the office, and so you might think mentorship is this idea that there's the great person who shares their wisdom. What he did, which was, he just immediately had a conversation with you as though you knew something. He treated you with respect and as an equal, and it was all about the idea. There wasn't a shred of ego in it at all. It was all about the idea. And that is actually the most powerful kind of mentor one can have, because he shows you the way the enterprise is supposed to be done, and he lives it despite this kind of stature he had. And of course, I learned way more from him than he did from me, but that's not the way that conversation was structured, and that was just incredible.
I just wanted to say, this is not about Stephen, but with Ernie, that he was away my first year law school, and my small group Professor Skane said, I think you have to meet Professor Weinrib. And so he was back from Yale, and I remember coming up to his office and asking him, what do you think the philosophy of law is? Like, I would ask very silly questions. And he said, that's what I'm trying to think about now and figure out. And I felt like something that I've never felt with any other teacher. I almost felt that I was talking to my brother almost. And I felt immediately accepted, immediately wanting to study with him. And there's no teacher in my life that had more significance for me than Ernie. And in the years that followed, I just want to say that, we have DRPs and all this kind of thing. Well, I ended up taking more DRPs with Ernie than I should have that was considered officially acceptable. When I asked him if I should take commercial law, he said, why do you want to learn different ways of selling a used car? But I trusted you, and I'm very happy I did. And what was the most amazing thing is he would give of his time, hours, and we would sit side by his desk. I'd run up to as soon as I was free, I'd run up to his office, his little office, sit next to him, side by side, and we would study books together. And, you really did change my life completely. And you were the greatest teacher I could ever have and could ever imagine, and you gave of your time so generously. And that's why law school here was for me the highlight of my studies, and before and after.
So I was never a student here, at least officially, but the first week I was appointed in the philosophy department, I went to this law and philosophy discussion group in Ernie's office, a group that has been meeting continuously once a week during term since 1979. And a couple weeks in, Ernie circulated a paper, and I thought, this is the kind of thing like a philosopher could sort out in a couple of hours. And a few weeks later, I had a couple of hours to spare, and here I still sit. So week in and week out over the decades, it's astonishing. We would spend years reading old books and talking about them. So we had a very strict rule that it required unanimous consent to move forward to the next page, but anyone could unilaterally move us backwards. Mm-hmm. And that did not make for a fast-moving experience, but it made for a deeply moving experience. There was just an incredible opportunity to learn. And just picking up on Mayo's actual question as she worded it, I think one of the things about all three of the people who were discussing was the way in which they really took the law seriously. The earlier panels raised issues about interdisciplinarity, and I think the same thing is true of everyone we heard about earlier today. It was multidisciplinary or interdisciplinary, but it was always about the law. And although Michael confessed to feeling badly about teaching contracts based on the standard set of materials, there's a way in which that's part of what it is to have a common legal culture. And that's also part of the reason that I could, if I ran into you in the kitchen, start up a conversation about something, because we had a common set of texts that we knew. And it turns out, because these are, as it were, the central cultural products of a sophisticated legal system, they're rich and they're deep, and they have survived not because there is consensus about them, but because they are so deep and they allow people to move around in them. And in a legal culture, of course, which is in some ways adversarial, that is the source of richness in the culture. But that meant with Stephen and with Michael and with Ernie, there was always something to talk about regardless of where you were coming from. And I think that's the thing that enabled Marty's mentorship to support these three very different modes of scholarship into a single unitary intellectual culture.
Yeah, and I mean, the other element I just wanted to emphasize, but I think it's there with all, it's also that commitment to shared deliberation with others who don't necessarily share your view, your interpretation, or anything else. So I just wanted to emphasize that part as well. That's wonderful. Thank you.
Can I just quickly just supplement that? I mean, I think one of the lucky things about doing law and economics at this law school is that it never, at this law school, it was never a kind of fault line like the other law schools that we can think of, kind of disintegrated around law and economics versus everybody else. And I think there's a lot of reasons for that, but the biggest one, I think, is Michael. Like, Michael never viewed, as I say, he wasn't a law and economics chauvinist, and so I think that he set the tone. It's a very good point.
Thanks, Chris. I just had an observation to make about Michael, and Ed, you might want to respond. I think that the main characteristic that makes Michael tick is that he's the ultimate autodidact. Well, that's hard to say. He's the ultimate autodidact. He went to law school in New Zealand, and New Zealand and Australian legal education is very much in the British tradition, very much black letter law and formalistic. And I'd always been curious, given that background, to know what got him into law and economics. And I asked him recently, and he said, well, at the time he was at the University of Adelaide, and he'd just been appointed to a committee to look at consumer credit law reform in Australia, and in particular truth in lending. And truth in lending has quite a lot of mathematics behind it, calculating the interest rate for disclosure purposes. And he said, well, I thought to myself, I better learn a little bit of economics so I know what I'm talking about, that I'm going to deliver an argument and not a visceral grunt. So he's not a trained economist. He taught himself economics so that he could complete this project in a credible way, and then came to Canada, and it all took off from there. And his autodidacticism didn't confine itself to economics. It went on to feminism, the feminist literature, institutional economics, immigration, development, and he taught himself all of these things. And then the ultimate was his appointment as the first ever non-US chair of the American Law and Economics Association. Not bad for a non-economist, I'd say. And I would say the same about the works that Ed highlighted, the Inequality of Bargaining Power paper, and the brilliant book on Limits of Freedom of Contract. Who would ever have thought a non-economist would be capable of writing works like that?
So there's a few people who have their hands up. I'm going to walk the mic over to Alan, but as I do, I just want to offer a story of my own which parallels Ed's story about the kind of egalitarian character of the folks we're talking about, which involves Ernie. So shortly after I graduated from law school is when Ernie gave the Killam lecture, the public law and private right paper, and I asked a question at that talk, and when I asked the question, in my mind, like, I'm just some kid, right? Like, I'm just some guy who graduated from law school a couple of years earlier, and then some number of years later, like 4 or 5 years later, we're at a workshop in the Michael Chabot Solarium. And somebody asks a question, I think it was an octagon, asked a question and Ernie answered, and they kind of go back and forth. And then at a certain point, Ernie says, like, in a way, this is just like a meditation on an answer that I'm trying to give to a question that Chris asked me 5 years ago. And the idea that, like, this question that I had asked him when I was, again, by my lights, just a kid, is such a great illustration of the same point, that, like, you know, that part of the amazing way in which these folks are mentors is the way in which they're willing to take seriously people, even the time that they are really just a kid. So thanks for that, Ernie. Alan, over to you.
Thanks, Chris. So Mayo said that we are who we are because of these three people, Stephen, Michael, and Ernie. And I'm sure each of us can tell a story about how we are who we are because of one, two, or three of them. But I'd like to tell a story about how I am what I am because of Ernie. I did a PhD in political philosophy, and as a result of the dryness of the job market at the time, I came to law school. And I can't say I was very happy to come to law school. It was a bit of a downer for me. And I didn't think I wanted to be a lawyer. But then I met Ernie. And I met someone with a brilliant mind, of course, a gentle character, but also someone who showed me that I could pursue philosophy in the context of a law school, could aim for an academic career in the law school, and that really gave me a total lease on life. So that's one way in which I am what I am because of Ernie. But another way I am what I am because of Ernie is because he offered a Kantian philosophy of law that I could define myself against. So in all these ways, thank you, Ernie.
Thank you. Okay, I'll try not to get emotional, but I do need to acknowledge the mentorship that Michael has given to me personally, and since people are sharing personal stories, I think it's worth sharing that when I got the offer here, I believe it was Mayo's first hire. Michael called me. I was in New Haven, Michael called me, and at the time I had an offer to go to a Brazilian law school where family was, where the weather is more amicable. And I had the option of coming to this very cold country that has a wonderful law school, but I have no family, nothing here. So Michael called me and said, think about this in terms of reversibility. Like, if you come to Toronto now and you don't like it, you can go back to Brazil anytime. Because spending 1 or 2 or 3 years at U of T will only enhance your CV, and your prospects in Brazil will be even better. But if you go to Brazil right now and you hire somebody else to be our law and development scholar, then you cannot easily call us back and say, hey, do you want to hire me again because I'm unhappy in Brazil? So with that killer argument, I couldn't say no. And here I am, literally, I think it's going to be 20 years later next year. So that's the story of Michael, beginning of his mentorship. But I think I have told many people this, that when I look at my colleagues who graduated from law school with me, went to grad school in the US, and went back to Brazil, I can tell you that they became wonderful scholars, but I think the scholar that I became is a much better scholar because of Michael's mentorship. So working with Michael all these years made me a much more refined thinker, a much more sophisticated writer, and invited me to, I think, confront questions that I would be very shy to confront otherwise. But Michael was like, no, we're going to write a paper about this. And I'm like, that question is so big. No, we can't. And he's like, no, we're going to do it. So thank you, Michael. I want to thank you. And I just want to add one gloss on your presentation about Michael's work. I see Michael's trajectory as uncovering the system behind what he's analyzing. So he starts with consumer law, and then he's asking what's behind this, and then he moves on to contract law, and then he asks, but what's behind this? And then he moves on to competition law, because there is a market behind all these contracts. And then when he turns to competition law, he's seeing competition across borders, and he moves to international trade. And once he gets to international trade, he's like, but what's the entire system behind this? And law and development comes in. So I just see Michael as this curious scholar uncovering the systems that are governing everything that we're concerned about. Thank you, Michael.
Okay, so briefly, so I really enjoyed this session. I'm not in the same field as any one of the 3 people being discussed, but the one thing I very strongly have an impression of each one of these individuals is their commitment to pluralism, their welcoming of somebody who did something completely different. So I really enjoyed that relationship. I also have to say, I thought the 3 presentations on these 3 people were brilliant. I really did appreciate that. I think I have read the idea of private law a few times. I now understand it. I wouldn't say completely, but I do understand it better than I did before, now that it's very well summarized by Arthur. The one thing, of course, I would add to Peter's talk about Stephen, who's a wonderful colleague, he was a very fine historian as well, and if he decided to devote himself full time to that particular academic discipline, then because I talked about a little bit of this about his our memorial event for him, and he was a wonderful historian. I actually have one question, which is for Ed. So Mayo picked out from that quotation from Peggy Radin the second sentence. I was struck by the third word. So Tripulco is unique. Now what Radin seems to me to be saying is that she doesn't care for any of the other adherents to the economic paradigm. The only one she can stand, because he does do justice to the complexities of relying on the market, is Michael. Could you respond to the word unique?
Complexity of views about the appropriate scope of the market domain, and I think she's right. And I think she's probably still right. So this must have been 92 that she wrote this. Came out in 93, and so. And I'll speak for myself. I'm like Mariana, but even more fearful because I won't write it even with Michael to come up against these kinds of questions. So I view myself as kind of working in areas where I feel safely that economics has something important to say and maybe even something dominant to say, sometimes for institutional reasons, because there'll be other areas that can deal with the bigger questions. So I think there's those of us. I think there's a number of lots. I might be the most common kind of line economic scholar who just thinks like I'm going to stick to areas where I think economics has something important to say. But then there's also a significant number of people who actually just think economics has everything there is to say, and those are the ones where I think Michael really objects to. Actually, I think it's stronger than just doesn't go along with it. I think he objects to it. I think he, and I agree with him. I mean, I agree with him. I don't have the same confidence to say, I think this is what should be done about surrogacy contracts as Michael, because I think it's just very hard to answer that question. But I know he's right that he's exploring the right ideas. So I think he is kind of unique. It's not everybody thinks that economics has all the answers, but some do, and those who don't think it has all the answers are still scared to take on these kinds of questions. And I think that's still true. So he limits of freedom contract remains a unique contribution. I think that's fair.
So we've got a couple of minutes left. I wonder if I might coax Michael or Ernie to actually see if they might want to say something about the theme of the conference, right? So I think one thing that I'd be curious to hear about is sort of your thoughts about what it is about your career that you might think, we might want to keep in mind as we sort of look to the future of the law school, as we look to the future of the legal education and legal profession. What if you were sitting in the seat of the driver's seat, what might you advise us to do in terms of the way that we're thinking about how we educate students or about how we conduct the research that we conduct or anything like that?
Thanks very much, and this has been a very illuminating session, and I just want to express my appreciation, of course, for Arthur, but also for Ed and for Peter about what they said. I think it is the case with that one reason that the law school faculty has never split along these along the lines that other faculties have split along is that Stephen and Michael and I, while doing different things, always completely respected one another. That is, I knew, for instance, and those who as deans had us sitting in on the appointments committee will recall that I don't remember being there with Stephen, but I do remember being there with Michael, and it was evident that despite our different views about how to analyze law, we were actually engaged in the same enterprise. That was abundantly clear, and as far as, and I want to say something special about Michael. I could say something special about Stephen as well, whom I knew probably more than anyone else in the faculty, for longer than anyone else in the faculty, because we were actually undergraduates together in the classics course, which had a total number of students that was just a slightly larger than the number of people at the table. Michael and I came to the University of Toronto the same year, 1972. Michael, I think, had been in McGill before, but we came here the same year, 1972, and as a result of that, we were. This is going to be hard to believe, isn't it? We were actually called to the bar on the same day. That is, we got an academic call. And I remember, Michael, we had a very stern judge giving us a lecture about something or other that he thought he was qualified to give us, something about personal character. Anyway, we were also at the Yale Law School the same year. My reaction from being at the Yale Law School and teaching that year was, this is a great law school. This is a really great law school. And they had offered me the opportunity to stick around. My reaction, my sort of intellectual reaction, there was a sort of a personal reaction as well, that Lorraine told me when I got the offer, you can fantasize about this for 20 minutes, but you know we're going home. But the intellectual content of it was that I thought we could continue to produce, that we were on a trajectory and could continue to produce a law school that would be fully the equal of the Yale Law School. And I was, and in a sense, coming back to the University of Toronto, the whole activity, at least as far as the faculty was concerned, was to try to promote that vision of what a really top-class law school could do. And I can't say how delighted I was that Michael also came back. That seemed to be a necessary element, in the mix. Now, I'm not much for giving advice, but I just want to make a couple of comments about my own career that might be worth keeping in mind. However, especially as students become, I think over I don't know if the last couple of years, but I sense they're becoming more and more anxious of the future and what they should study to prepare for the future. And I think my legal career was, in addition to the wonderful colleagues here, was blessed by a number of factors. One was that I had the good fortune of never studying law at the graduate level. And by that, I mean that when I was hired, I had absolutely no preconceptions about what the job was. And I mentioned earlier that Marty tried to help me out to figure that out. But I had absolutely no idea what the job, okay, now I'm teaching law, what do I want to do? What am I supposed to do? I remember my brother telling me that he had been told by my own torts professor, Ted Alexander, with whom he was on very friendly terms, that Ted had said that, oh, well, he'll do something completely new. And when Arnold told me that, I thought to myself, completely new? What could I do completely new? All I knew about tort law was what Ted had taught me. The possibility of doing something completely new was didn't seem realistic. But I think the idea of giving people space to just think about what they want to do and what issues they want to pursue and how they want to pursue it. I think this is crucial. I'm not so sure it's in tune with the ethos of the modern university, but I think it's crucial. And I remember after a few years of being on the faculty when I had written basically nothing. But Marty wasn't pestering me about it. I remarked to Lorraine, who was, this was before she joined the faculty, she was then working as a constitutional lawyer for the Attorney General of Ontario. I said, this academic position is very odd. I seem to have to neither publish, nor am I doomed to perish. I can simply go on. It's very, very odd. Anyway, that problem resolved itself in due course. The other thing that I want to mention that I think was decisive for me is that, and for all I know may have been decisive for Stephen too, is that I was trained in classics. I was a classicist. That is, my training was in reading Greek and Roman texts and thinking about the whole culture, the literature, the architecture, the history, and then pursuing that at the graduate level, and thinking that I wanted to become, and did for a while become, a professional historian. So actually, Jim, history is the only thing I'm actually trained to do. But I think that, and I was remarking on this to someone earlier, I think that turned out to be actually a perfect training. Now, it shouldn't be surprising that that's perfect training. After all, that has been the historical function of a classical education since the 5th century, that a classical education provides a perfect training for whatever you want to do. And so, so I think we should be encouraging of those people with that kind of background, and I think in my case, it also had the advantage of instilling a certain sense of what scholarship and mentorship was, because I had the most wonderful teachers in classics, as I had in law, but they were wonderful teachers and mentors whose impression on my intellect I still feel to this day. So I think one of the blessings of having students of a law school is that it's open. It's not only open to talents in the classic sense, but it's open to all kinds of trainings or backgrounds. And in my case, that meant that for me, law has never actually been a social science. That's just the odd truth of it. And whenever I had to fill out those forms for the shirk, and found myself in the social science category, I bridled against it and said, well, how do I fill this out? That law was always for me related to the humanities. It was, and I think it resonates with what Chris said. Sorry, this morning about Caesar Wright and the construction of a civilization. A civilization is constructed in many different ways, as we know, but I think what the university is about is actually being inculcated into the values of civilized life in whatever form they take, and the values of a shared culture, and the values of a shared literature, and so on. So I don't have any prescriptions about anything, but I'm very thankful to have spent these many years, I guess it's now more than 50, at this law school, just as I was regard myself as being very fortunate in having got my law degree at this at this law school. So thank you all. That's really all I have to say.
Thanks, Marty. Did you want to say something, Michael?
Thanks, Chris, and thank you, Ed, for your very generous comments, and Mariana and Tony and other colleagues. One thing I am often pressed on to explain is how come you've worked on so many different topics, right? A book on this and a book on that, and public inquiries one year, the regulation of the professions, then immigration policy, then trade policy. You can't possibly be an expert in all of these areas. Oh, well, of course, that's just true in some sense. I could, as some folk do, I could spent all my career working in international trade law, but this would have bored the wits out of me. So I guess this is a way of making a confession that I have a short attention span. And I bore easily. I don't, there's no point in apologizing for it. Mariana was very kind in her comments, but our academic relationship has been totally reciprocal, right? We've co-taught the law and development course for 15 years.
More than that.
We've co-authored 2 books and 2 or 3 articles together. We have vigorous debates. We don't come at these issues from different planets. We more or less agree on most of the time, right? Tony said I had no training in economics. That's a bit. It was a bit crestfalling. But the truth of the matter is I did spend, first a month in the Rochester Henry Manny program in law and economics. Then I spent most of a year as a fellow in law and economics at Chicago. So I did make some serious attempt to redress my earlier shortcomings to greater or lesser extent. A couple of other points. One, picking up on Ernie's point, I am eternally thankful that we are a diverse faculty with very diverse perspectives, and we respect each other. We don't spend endless time or any time with faction fights over hiring or this or that, at least not in my time. And I think schools that elect for a single dominant perspective, I'm thinking of the Scalia Law School in Washington, I think this is a grievous mistake. I'm absolutely delighted that I have lots of outstanding colleagues that work in different perspectives from me, and I've learned a lot from them. Just an example of why I don't think economics is the beginning and end of any serious analysis of major normative dilemmas. My book, Dealing with Losers, the Political Economy of Policy Transitions, I think highlights this. I take on Lewis Kepler, a leading law and economics scholar at Harvard. He says, well, if the political institutions in a country choose to change the laws and render people worse off, so be it, right? That's just another risk of life, right? Like people changing their preferences for different toothpaste or whatever. I think that's not the way, and I see this playing out today in the U.S. The idea that you can just lay off people randomly right, in large numbers, people with families and mortgages and so on. And even if one assumed, which I do not, that these policies are well conceived, which I reject, but even if they were well conceived, the idea that you can throw these people to the wolves deeply offends me. I wrote a book on dealing with losers, dealing compassionately with losers from policy changes. And this is a particularly salient issue with trade policy. You know, Trump talks endlessly and incoherently about bringing back manufacturing jobs to the U.S. and how he's concerned about folk losing jobs in the Rust Belt of the U.S. Well, he's right to focus, or at least draw our attention to the fact that there are losers, but his response to this is completely irresponsible. That is provoking a global trade war. So we, people like me, should feel it incumbent on them, people teaching trade law, to come up with a more constructive set of policy responses for mitigating the employment impacts of imports. So I take the issue seriously, but as kind of a zero-sum policy of the U.S. raising tariffs, we raising counter-tariffs, this is a total insanity, right? I can't think of a worse set of policy responses. But I do take the problem of dealing with losers seriously. It turns out the U.S. as a percentage of GDP has the least generous passive and active labor market policies of any OECD country. So it tells you more or less everything you need to know. What else? Ernie and I don't know whether we've ever crossed swords directly on it, but just to illustrate how he and I would come at issues quite differently. I think most people out there, or in the room or out there on the street, if you were to ask them, when you think about the possible impact of an accident, a traffic accident, a workplace accident, a product defect, the possible impact of an accident on your life or your family's life, what two things are you most concerned about? I think you would get a 90% answer. How to prevent the accident if it can be prevented, and how to deal with the health and financial consequences of the accident if it does happen. So for me, I co-authored a book on exploring the domain of accident law. You notice I don't call it tort law, accident law. That is the whole plethora of regulatory and tortious and other mechanisms, to reduce the risk of accidents, including a book with Marty and Ken on traffic safety, how to reduce the risk of accidents, and then how to ensure reasonable access to health care and a cushion against financial consequences for accidents that still do happen. So there I'm interested in disability insurance or no-fault workers' compensation, how well that has worked, whether we should move to no-fault auto insurance. But I suspect Ernie is not interested in these issues, where for me these are central to my preoccupation. So I don't think of tort law, I think of accident law. But I'm happy to let Ernie rejoin that.
Did you want to say something, Ernie? Yeah. This is what I've been waiting for 25 years.
we actually, Michael, it's very interesting that you say that. We actually once did have a disagreement on exactly this, but it was about 40 years ago. Yes, you're right. I'm not too much concerned about that because I know you are. And you can think that aspect of it through much more thoroughly than I can, and I am sure you do. The question that does arise as a theoretical matter is how does one reconcile the possibility of these two different ways of dealing with accidents? And as Arthur said, that's an issue that I actually had some thoughts about in my reciprocal freedom book. But yes, I'm not, as I say, I'm not interested in that part of the question, but I don't deny that it's a real issue. But as I say, I'm sure you'll do a good job on it. But that doesn't solve the other issue. Well, that's fine. I don't mind that. That's fine.
As you just said, it's a perfect note to end on. Thanks so much, Michael and Ernie, for those comments. And to the members of the audience and to the panel for really wonderful presentations. So thanks very much. That concludes today's events. We'll reconvene tomorrow. I'm asked to say to the members of the faculty, current and emeritus, can everybody come over here because we're going to do a picture? That's what I'm supposed to say? Yeah, we're going to do a picture. Thanks.